Honorable Justice of the Appeals Court, now sitting in Boston, far within the Commonwealth. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is now open. Please be seated. Come on, Your Honors.
Good morning, everyone. Welcome to the Appeals Court. My name is Chief Justice Amy Blake. To my right is Justice William Meade. To my left is Justice John Englander. We are the panel for the 5 cases that we will be hearing today. Our intention is to hear the first 3 cases and then take a brief morning recess. I know most of you have been here before, but as a reminder, oral argument is 15 minutes per side. There is no rebuttal. We have read all of your materials, so I urge you to get right to your arguments. And with that, I will call the first case, Commonwealth versus REECE Collins, docket number 24P548. Counsel, good morning.
Good morning. Good morning, Justices. May it please the Court, Penelope Cathawala for the appellant REECE Collins. Getting right then to the issue, as Your Honor knows, or Your Honors know, the Commonwealth has conceded there was insufficient evidence for the against Mr. Collins for the charge of larceny from a building. The Commonwealth then, via brief, has put forth that the lesser included offense of larceny, there was sufficient evidence. We are, of course, suggesting that that is not correct. As Your Honor know, under the larceny statute, unlawful taking of a property of another with permanent intent to deprive, and I'm suggesting in this case, number 1, there was insufficient evidence on ownership. I suggest if you, and you say you have read the transcript, so you will know this is a situation where a husband and wife were lessees on an apartment. The wife's brother and his girlfriend came to live with them. The lessees were, of course, responsible for paying rent. There's testimony, most especially by the brother of Mrs. Her name is Souza, but the wife of Mr. Collins, that he would either, the brother would either give the money to, for the rent, his contribution, to Mr. Collins or his sister, Mr. Collins' wife. So I'm saying, and that is at transcript 133 to 134.
You know what else it says on page 133, though? The brother-in-law says that the defendant stole the money that his sister had hidden.
Well, that's what I don't believe he said he stole it. I don't recall that it was the word stolen, but I mean, of course, you have the transcript right there. I'm just suggesting that the money was given to the 2 lessees, whether it's the husband and or the wife. It was the husband's responsibility, or both of the lessees, to pay the rent. So if you give it to a husband and or a wife, I mean, isn't it?
Here's the question. But REECE, according to you, originally took it so he could pay the rent, right? No. He did it like he was stealing it.
Well, I think in the other section, he said we always gave him the rent and he paid.
But what's our standard of review? We have to view the evidence in the light most favorable to the Commonwealth, not to the defendant.
Yes, yes. Well.
So in the light most favorable to the Commonwealth, we have evidence that he stole the money.
And I think there's evidence to the contrary where he.
Yeah, but contrary evidence doesn't make it insufficient.
Okay.
Well, the problem really is whose money is it, right?
Correct.
That's the argument that you're making.
Yes.
Right?
And the permanent intent.
The evidence as to that has to be viewed in the light most favorable to the Commonwealth, right?
Yes.
And what exactly does the wife testify on that, and what exactly does the brother testify on that?
Well, the wife said she got the money and she hid it in her dresser drawer. I believe the brother said it was given to her and she put it in a pink bag or a pink sort of holder. Nonetheless, I believe the dresser drawer was utilized by both Mr. Collins and Miss Souza, the husband and wife. So, of course, our position is that he was responsible for paying the rent. In fact, that rent was due several days later after this Thanksgiving event, and that rent was paid.
But when he took the money from her, and he taunted her and told her she's not going to get it.
Well, I don't believe he said that. I thought the quote was, "I have the money," or "I'm leaving with the money," or "I have the money," and left.
How much time has to pass for there to be an intent to permanently deprive?
Well, it could be a minute.
Right, there's no magic timeline.
Right,
And we look at the facts and circumstances surrounding it.
correct.
The fact that he later returns the money, is that evidence that the evidence was insufficient, or is that evidence of consciousness of guilt?
Well, he was responsible to pay the rent. That's one thing we know. He and his wife, they were the lessees. And he came back with it because he needed the balance of the rent or was going, I mean, we don't know that from the transcript, why he came back, but he did come back. And I believe he resided there somewhat for a couple of days. He went to his father's and then he came back. I mean, that's a husband and wife were both responsible. We do know that the money was a contribution from the brother. So the brother gave the money away and gave it to the husband and the wife. Physically okay, but I think somewhere in the transcript he also says he gave it to Mr. Collins, and that he further said that Mr. Collins was responsible for the actual payment of the rent, but that his wife would, Mr. Collins' wife, his sister, would sometimes pay it. So I'm suggesting the ownership interest is not defined here other than it's Mr. Collins and/or his wife, and it was money to pay the rent. Certainly when the brother handed it over.
What's the evidence that it was money to pay the rent?
Where's the, well, it's in somewhere in the transcript. He said we contributed to the rent, we paid $500. And that was their contribution to the overall rental. They came, the two lessees were the husband and wife. Mr. came over with his girlfriend, and they made contributions to the rent.
If the money is joint money, then there can't be a larceny case, right?
It can't be a what? I didn't under.
Can't steal from himself.
Correct.
So if the money is jointly owned, then there's no larceny case. That's your position, right?
That is my
Do you
position.
have a case that says that? I mean, I'm assuming in the context of joint bank accounts that this has happened.
Well, I mean, all I cited was the Johnson case with respect to ownership. That's 63 Mass App 855 at 859.
Does it talk about a joint ownership issue?
No, it just talks about ownership and sufficiency of ownership.
Because
I guess that's a probate.
The evidence is, as Judge Meade said, he taunts her. He says, "I'm taking this, you're not going to see it." That's what the evidence was. If it's his money too, then I'm not sure it matters that he taunted her, but that's what I'm asking about. What's the case law?
Well, I don't know a case where it was a husband and wife taking, because
I don't know
they
that it
won.
matters as a husband and wife. The question is whether the facts are such that as a matter of law, it's established that it's jointly owned, it seems to me.
Okay.
Because otherwise, you got a problem, because we got to take the evidence in the light most favorable to the Commonwealth. Okay.
Well, I'm suggesting that, frankly, the money was given to either Miss Souza or Mr. Collins to pay rent. It was given over by Mr., well, the brother-in-law, I think his last name was Raul. He knew then, once he gave it, it wasn't his. So now
The money was hidden in her clothes, right? He went and found it and took it and, as we've discussed, taunted her with it. All of
Well,
those circumstances.
They certainly were having an argument, but they certainly both were obligated to pay the rent. So the question is the contribution from the brother to either his sister, the wife of Mr. Collins, or to Mr. Collins? In fact, they were marshaling up the rent money to pay the whole bulk of the rent. So in some way, you could say the money was in transit to the landlord.
So
And it wasn't-
the brother-in-law testifies that the rent money he gave to the sister, which she hid. And then he says that the defendant was being vicious, like, quote, "I have this money, you're not getting it."
Well, it wasn't.
Why isn't that an intent to deprive her from the rent money?
Well, the money was to be used for the rent, so I don't know.
It's not going to be used for the rent if she's not getting it.
But he was responsible to pay the rent, I think.
Did he pay the rent with it?
Yes, the rent was paid. Yes, he returned with
Did he? Oh, okay, so he returns the money.
Well, he went back and they paid, well, we don't know if
Why,
he gave.
if he returns the money and he's the one that pays the rent, why isn't that evidence of his intent to deprive her of it? His realization that the money was not his, that's why he returned it.
Well, I don't think we know that from the transcript. I think we know that the money's, here's what we know, the rent was
So far,
paid.
we've not known a few things from the transcript, and then I found them both.
Pardon? Sorry, you didn't hear.
What is your argument?
My simple argument is that I'm suggesting he went back to the house where he had a leasehold interest in. They had an argument. He took the money he was marshaling up to pay for the December rent.
He wasn't marshaling it. The brother-in-law gave her his share of the rent, the $500. He took it from her, then the money was hidden, and said, "This is mine, you're not getting it." And he did not pay the rent with it. He gave the money back to her, which the inference can be drawn that he realized that the money was not his. It was hers.
Well, the money was hers. I'd suggest to you respectfully that it was hers to pay the rent, which was also his responsibility.
Who had
Wasn't hers to-
who had a greater possessory interest over the rent money?
Well, they both signed the lease.
Who hid the money?
Well, I'm not so sure she hid it. She put it in a drawer.
You keep doing this. The
Right.
evidence in the light most favorable to the common law
Yeah,
is that she hid the money.
Okay, she hid the money.
This is not a jury argument.
Okay, yes, I understand that. I'm suggesting that they both utilized that dresser drawer. I think the wife testified it was hidden under her negligee and intimate apparel. And I think that the brother said it was in some pink holder. So I don't know. As you know, the witnesses were sequestered in this case, so there was a little difference as to where that money actually had gone and how.
But the bottom line is the money was hidden.
Okay, but yes. In a dresser they both utilized.
So she had a greater possessory interest in the money that she had hidden.
Okay.
Is not a fair inference.
It's a fair inference, right, other than the fact that they did both utilize the dresser. It was a joint dresser. So.
And what is a fact finder to conclude from when he takes the money and taunts her viciously and says, "You're not getting it"?
Well, maybe because he was going to, I think you can also draw an inference that he was going to say, "I'm going to pay the rent."
Well, the Commonwealth
Or-
doesn't have to exclude innocent inferences that could lead to a conclusion of innocence, just the ones that are fair to show guilt.
Yep.
And he says, "You're not getting it." One could infer that he intended to deprive her of that money.
But then the question becomes, was it her money? It was a conduit to pay. Both of them were, I'm just saying, he had a responsibility to pay the rent. She had a responsibility to pay the rent. So it, in theory, was not her money. It was monies from the brother paying his share.
You're missing the point of what I'm saying.
I-
The brother-in-law has testified that sometimes his sister paid the rent, most of the time the defendant paid the rent. The $500 that he took that was hidden, he did not pay the rent with it. He gave it back to his wife, and she paid the rent with it, because he realized, the inference being that it was not his money. to take?
I will just say, I think it was both their money to pay the rent, but that's just my argument here before the court today. And with respect to intent to permanently deprive, I say the thing, again, I know this case law says if you leave with it, you know, there's an intent to permanently deprive. I'm suggesting it was not, especially because he returned it.
That's a jury argument, though, isn't it? I mean, that piece is a jury argument. Yes, you could argue to the jury he didn't intend to take it. It was an argument. He was in a huff, and he left. But the jury can certainly infer from what he said at the time that he intended to take it permanently.
Well, yes, the jury.
Okay.
Yes.
The Commonwealth cites a case from 1931, Commonwealth versus O'Connell, that says the defendant is guilty of larceny even though he takes the money with the idea of using it temporarily and later returning it.
Well,
Why isn't that what happened here?
Well, I would just suggest that O'Connell and Ellison cases, by the way, were embezzlement cases. And I think those elements are, you know, and by the way, I would suggest that embezzlement doesn't require an intent to permanently deprive.
The portion I read was a quote, and I used, and the quote is larceny, not embezzlement.
I didn't hear
It's
that.
larceny even though he takes the money with the idea of returning it. It's still larceny.
Understood. Yes,
That's what the SJC said in the 30s.
understood.
Unless the panel has additional questions, I think we will have to leave it there as the red light is blinking. Thank you, counsel.
Oh, thank you. Thank you, Judge.
Attorney Nadeau?
Thank you. Good morning, Your Honors. Madam Chief Justice, may it please the Court, Stephen Nadeau on behalf of the Commonwealth. As indicated, obviously, we have conceded that the felony portion of the conviction for larceny in a building cannot stand. Our position,
But does it have to, if we affirm the lesser, does it have to go back for resentencing?
Yes, yes, and that seems pretty clear based on Sullivan cited in the conclusion. As to the sufficiency on larceny itself, I do note that there was some conflicting or ambiguous testimony about the usual routine of, you know, paying rent, but the question of the taking of this particular money on this particular occasion, the evidence was sufficient to permit the jury to find
Whose
that.
money was it?
Sorry?
Whose money was it? Who owned the money?
I think it could either be viewed as the Walls or his sister's, Katerina's, and
But not as the defendant's?
I believe not under these
Isn't the
circumstances.
testimony consistent that he was giving rent he was paying $500 so that these two people who jointly owned the rent could pay the rent? That's the testimony, right? It was always, give it to me to give it to REECE. This is the wife. You didn't keep it in the kitchen drawer? No. I say the $500 is in the kitchen drawer? No. Shortly before the rent was? No. We never left it in the kitchen drawer. Okay, and so your brother would always give it directly to you, correct? To one of us. Us. Because
And-
us owed the rent.
But I would suggest that that is on other occasions. Perhaps it was given to the sister, then given on to the defendant, but here it was not.
But why does that matter? I mean, if the purpose of giving the money is so that the obligation of the two of them can be paid, how is it that the husband has no rights in the money?
Because it was never given to him, I would suggest, and I would refer to Hartnett, which is the very old case that says that, you know, a husband and wife can't be charged with convicted of larceny of building from stealing with their own house. But
I hand the money to X, and I say, use this money to pay a joint obligation. And then, and it's a joint obligation of X and Y. Okay? And there's no inconsistent testimony on this. He gives the money to pay a joint obligation of X and Y, but I give it to X. Your argument is X is the only owner of the money?
At that point, yes.
Any case that suggests that? Because I would think that the law would say X holds that money in trust for Y to pay the joint obligation of X and Y.
Because it was never came under the defendant's control, possession remained hidden in.
But everybody understood what it was for. It was for both the obligation of X and the obligation of Y. Is it your position that in light most favorable to the Commonwealth, what I just said is wrong? Because it seems to me, at least the way I'm thinking about the case, that's the only way you can win. If I was wrong with what I just said, that it was to pay the joint obligation of X and Y.
Well, I think the intent of giving it to pay a perhaps joint obligation does not create joint possessory interest or control over the money. It was given to the sister for use of the rent. She hid it in her clothes, and the defendant stole it, not to pay the rent, but to take it from them.
Well, can I add a layer to this, which is I went back to the complaint at Record 8, and the complaint alleges that the property was stolen from João Rafael Benavides Souza, her husband, not her.
Well, I think that, puts the defendant on notice to a certain degree, but the element itself is the property of another.
It is, but...
As they're instructed, and in other words, not the defendant. So our position would be that, the complaint charges the elements, the victim themselves is not necessarily an element to be proven. That any particular defect in that regard was not brought up. But at the very least, again, possession from while to his...
Let me flip the hypothetical. I'm sorry. You're still answering the Chief's question. Sorry.
I'm sorry?
I'm good. Go ahead.
You all right?
Yeah.
Let me flip the hypothetical. The brother gives the money to the wife. They split before the rent is due. The wife takes off with the money. Does the husband have any kind of claim against her?
I would say not a larceny claim against her, perhaps some other thing, but if he did not possess the money and she took the money her brother gave her, that's not a larceny.
Not a larceny claim. How about a civil claim to get the money back because she just took $250 of his money?
Potentially, I'm not.
Well, but if he owns it, he can't be guilty of larceny from himself, I think. I mean, I don't know about the joint tenancy cases, but I'm assuming they're out there. Okay, if somebody takes money from a joint bank account, that's not larceny. That's my guess. If their name is on the joint account.
I think it would, again, very much depend on the particular facts of the taking, of the status of the property. Again, here it was only given to the sister, only hidden within her belongings. And on these particular facts, I think that's sort of a factual issue for the jury. The jury here could find that the defendant never had possession of the money. It was not his, and he took it with the intent to deprive. And I think that's rational.
I understand the point on the intent to deprive. I mean, I think there's sufficient evidence on the intent to deprive. I'm stuck on the whose money is it? Anything more you can help us with on that?
I think nothing particularly new, but I think, again, just looking at the Hartnett case, which is, just because it might be a marital property does not mean there's necessarily joint owner. You can still steal from your spouse. And the O'Connell-Ellison cases.
Slow down. So what's the Hartnett case? Because I'm not...
That's the one that early decided, it's from 1855, a man cannot be convicted for larceny of building from in his own home, nor a wife from property in her husband's home, because it's their house. Summarized in green much later as the building in question must not belong to the defendant. But Hartnett does go on to say that larceny can still lie as a conviction, even though the property may be, within the joint control of the domicile in that case. And then I would then kind of extrapolate there with Ellison that says even,
Those are cases about larceny from a building. Is that what? Is that?
Hartnett is. Ellison is
In the case
not.
about larceny from a building, it says if they're in a joint home, you can't be guilty of larceny from a building, but you can
Yes.
still be guilty of
Yes,
larceny.
Hartnett is a larceny from a building case, yes.
Okay.
But I think I've communicated the gist of the Commonwealth's position. Happy to answer any other questions the panel may have.
I don't see any. Thank you very much, counsel. The case is under advisement. Our next case is Commonwealth versus Michael Pardee, docket number 24P140. Good morning.
Good morning. May it please the court. Peter Brewer from Great Barrington, representing the appellant Michael Pardee. There's been some developments in the case law directly applying to this.
I was waiting for your 16L. It never came.
I'm sorry, Your Honor, and you're right.
Changes the whole complexity of the case.
It does, and I apologize, Your Honor. I certainly recognize that should have been the step that I followed.
So we all know what the new case law says.
Your Honor is probably referring to Oliver.
Oliver and Scordino.
And Scordino being sustained, Oliver being reversed.
So let me ask you this. Those cases leave open the possibility that there are circumstances under which people can still be convicted of these crimes. Isn't this the exact case for that? We have 8 checks. We have a history with the check cashing facility. We have memos of the alleged reasons for these payments. We have checks being cashed both before and after the victim dies. There's a lot more that we had here than we had in either Oliver or Scordino. So tell me why this case falls under that umbrella.
Thank you, Your Honor. I note that the difference here, for starters, from Scordino and from Oliver is this notion that, you know, we have to start with the idea that Mr. Pardee actually was the one who went to the bank. We don't have that kind of evidence here. That is only by inference.
This goes to a separate element. Do you want to talk about that? You want to talk about the sufficiency of the evidence that it was him who cashed the check, or do you want to talk about the issue that the chief raised which is not the issue? So
thank you.
You started talking about Oliver. Oliver raises the issue of whether the evidence is sufficient as to knowledge, right? As to whether he knew that the check was false. Talking about the identification issue is not an answer to that question. It's just talking about a different element. Which one do you want to talk about?
Thank you, Your Honor. You appropriately redirect me. The Commonwealth, curiously, proceeds with what I would say is, I mean, this is a fairly awkward case from the Commonwealth's perspective because they decided to proceed only on the usual and customary procedures at the check cashing facility. And in doing that, I believe that they basically put this case squarely into Oliver and Scordino by saying it was an unremarkable case. 8 times, yes, but nevertheless, they don't bring in a guy who actually, you know, guy or gal at the counter.
Are you challenging this? Are you challenging the evidence? I don't understand this argument quite either. Are you challenging whether the evidence of business practices should have come in as an evidentiary matter?
No, I'm saying 2 things, Your Honor, respectfully, and I'm not making my point well, perhaps. In response to Chief Justice's question here, I think the Commonwealth shows that these were nothing more than unremarkable events, even though there were 8 of them.
Well, you know,
that's my response.
Can I stop you there? I think what is remarkable is that the victim, Donna, doesn't know the defendant. Her son doesn't know the defendant. She's suffering from dementia. She was incapable of writing checks in August of 2020. The defendant never provided any of the assistance that were memorialized on the checks. And 2 of the checks were issued after Donna died. So I think that's pretty remarkable.
Well, actually, Your Honor, the Oliver case goes into that. And the Oliver case actually discusses this notion that checks are somewhat fungible. They are passed from person to person. I don't really see that if we assume, and I want to keep that a narrow assumption that it was Mr. Pardee who went to the check exchange. If we assume that.
That's where Manchester's testimony comes in. The import of all of that evidence about how the process works was to identify the defendant whose picture they had on file and was an exhibit at trial.
No, I understand that, Your Honor, but what I'm responding to
So that
is
identified him as the person who cashed the checks, is what I'm saying.
insufficient. I would say only by inference, Your Honor, but
Well, inferences are proper evidence.
they are proper inference. Inference upon inference becomes insufficient. An inference here that then would lead to the intent and knowledge would be still be insufficient
Why don't
under
we do it
Oliver and
this way,
Scordino.
Counsel, why don't we assume, for purposes of the knowledge issue, let's assume that there was sufficient evidence that your client is the person who cashed the checks, all right? Now, so we're just going to, right? Because that's a separate element.
I don't like, well, Your Honor,
It's a hypothetical question.
I don't like assuming the knowledge thing, Your Honor, because I think
I'm not
Scordino.
assuming the knowledge. I'm assuming the identification. I'm assuming it's him. Now argue why the evidence is insufficient as to knowledge. You say this case comes squarely under Oliver?
Both Oliver and Scordino.
Okay, but the chief points out that there are some different facts here, aren't there? Because the checks that he's cashing have on them a memo for what their purpose is. And I think one of them is contracting work at the house. And the evidence is in and undisputed that no such work was done. So this is a check made out to him, to his name, right?
Yes, but I would say based on Oliver, they do go into some of these.
So this is not a negotiated check in the sense that it was made out to somebody else and he's holding it. He's holding a check made out to him that says it's for contracting work. And the evidence that's in is no contracting work was done.
But if we make the assumption that, if we assume, just for the sake, that Mr. Pardee was holding the check, someone else could have written those notes. And again, the concept here with these checks is that somebody else could owe the money to Pardee, and it could be somebody else who wrote the note that they did construction work.
Eight times
Well-
at the place where he was a customer, because they already had all of his information, including his photo, on file. 8 times.
Your Honor,
Not a
again,
coincidence.
the 8 times thing, I think, is met by the Commonwealth using, and why they did this, I just can't imagine why they didn't bring in one of these tellers from Check
Because they
Exchange.
couldn't find them.
That's, Judge, I can't step outside the record. You're right about that. It's
You're asking
it's hard
a
to
question.
fathom.
There's an obvious answer to the
Well,
question.
but it is hard to fathom. But then the Commonwealth proceeds by making all 8 of these unremarkable.
Here's what I don't understand about your answer a few moments ago. Someone else could have written, you said, someone else could have written the purpose on the check. But her name is on the check.
Right.
So your assumption is that she wrote the check and then someone else added the purpose before your client cashed it?
It's possible. It could be the
But
person
then
who.
we're at Judge Meade's point that we don't have to
but-
exclude all possibilities, do we?
No, but
We also
have.
know that
have
it's
to-
not her signature. It's been forged.
You know, Your Honor, I'm going to ask the court to please take a look at the record appendix, because that particular argument troubles me the most. And again, I don't think defense counsel argued this, but when you look at the back of these checks and you look at my client's driver's license, there's no way that those 2 signatures, the endorsement of a Michael Pardee and my client's own driver's license, they're nowhere near the same type of signature.
The son testifies that it is not his mother's signature.
Absolutely.
That is evidence the jury can credit that it's been forged. In addition to that, they have the mother's, Donna's signature card on record at the check exchange.
They do not,
The jury
Your Honor.
has that, and they can see for themselves that they are not the same signature.
I'm sorry, Your Honor, they don't have Donna Berg's signature on record at the check.
They have
We have it
his.
from the durable power of attorney.
Your Honor, I believe it's the bank. The checking exchange place had nothing for Donna Berg. And that's what I find remarkable. If we're going to talk, if the Commonwealth wants to say it was a reasonable, strike that. If the Commonwealth wants to say all aid had to happen this way because this is how we do it.
Let me ask you this.
Let me ask you this.
No, you may not.
Thank you. I apologize.
I'm asking a question.
Sir.
Is it a fair inference that the defendant gave the victim the nursing care and the construction work after she died?
No.
Then 2 of these checks were issued after she died.
Correct. And your point, Your Honor.
My point is that that's ridiculous.
Well, I've indicated that I would say that Scordino and Oliver support the notion, especially with the language in Oliver about how these checks can have inconsistent statements on them, that my client didn't necessarily, if we assume he was the one who went in there, he didn't necessarily make those notations.
Well,
and he didn't necessarily do the work or pretend he did the work.
I have a more fundamental question. At trial, the defense was identity. Is it correct that you are raising for the first time on appeal the question of intent to defraud?
No, the elements weren't met, Your Honor.
I know that's what you're arguing here. Below, intent to defraud was not challenged. It was solely identity. Is that correct?
Yes, Your Honor makes a point. And I have to concede that. And I suppose it is, well, I don't think the defense counsel totally missed that, though, because I do believe he relied upon the inferences. And yes, inferences can contribute to sufficient evidence. They can't be inference upon inference. But perhaps you're right, Your Honor. Perhaps this is raised for the first time here. But I think
at 15 of your brief that even if he did cash the checks, showing that he cashed them would not suffice to demonstrate an intent to defraud or knowledge of forgery beyond a reasonable doubt. I don't see that raised in the trial.
And, Your Honor, I think you're right. Okay. I don't think I can go much beyond that, but I could argue here prejudice in the sense that those inferences cannot be piled up to infer, in this circumstances, knowledge and intent. And I think that is sufficient for the argument here at the appellate level. And I appreciate moving on here, unless there's further questions, on a couple of additional points. The biggest one of the big errors I see here is this question of permitting into evidence this name Stephanie Parson. I mean, I think that was a loud bell that just had to ring throughout the courtroom. And the
wasn't it admissible to rebut the defense that it was Stephanie who uttered the checks and not your client?
Well, but I think that wasn't. I think that was just raised in motion argument. That wasn't raised in the facts, Your Honor. I'd have to double check.
The judge made a ruling, and he let some in and kept some out. But you say that it was prejudicial. But your defense was it wasn't me, and he pointed his finger at Stephanie. Who is Stephanie? That evidence rebutted the assertion that Stephanie was the actual perpetrator, no?
Well, yeah, but again, Your Honor, that was just at the defense counsel also argued that it was irrelevant and prejudicial.
Right.
He didn't just argue there's no connection, and I think there's a whole ball of wax with Stephanie.
Isn't it relevant to rebut his assertion that Stephanie was the real criminal?
You know, I don't think that the evidence could adequately come in for that purpose, given the level of prejudice and the level of irrelevancy. Because, interestingly, Commonwealth points out to me in the brief that it wasn't really the checks that he's charged with stealing, it's the money. And so I respect that correction from Commonwealth. But I note on that point, then, it makes Stephanie Pardee's name even more irrelevant.
Well, she did provide nursing care for Donna, right?
She did, but it was a whole year before this incident.
Okay, so we also know that the nursing facility fired Stephanie because of this incident.
We're not sure about that. They fired somebody, because somebody was bringing, and again, I think a year before, somebody was bringing Mrs. Berg to the bank to take out money. So that got a little...
Did defense counsel attempt to argue that this other person who'd been fired might be the person who stole the checks?
I don't believe he did. I mean, I preferred, respectfully, I would have preferred a little more third-party culprit argument here. The court quotes a case, I think it's Spencer from Texas specifically, insufficient proof of knowledge where the defendant not implicated in the theft of the checks. Now, the only thing I think that gets Mr. Pardee near the Berg house is putting in the name of Stephanie Pardee, which I believe was highly prejudicial and irrelevant. And once again, forgive me, Your Honor, for speaking over you, and I thank you all. My time is up.
Thank you very much. Commonwealth?
Thank you.
Good morning, Your Honors.
A 16L from you would have helped as well.
Yes, I apologize. That would have been helpful. I understand there was new cases that had come out
In
since.
September. It wasn't breaking news.
Yes, Gordino and Oliver. And two cases that are very relevant to our case here. If you need any additional information from us afterwards, I'm happy to provide that.
I want to know how this case doesn't fall within the parameters. What's different about this case?
Yes. So in Oliver and Scordino, what I took from those cases were that cashing a check from somebody that you don't know or doesn't know you without an expectation of payment alone is not sufficient to support conviction for uttering or for even larceny later on down the line. We had issues for identity, we have issues for knowledge, we have issues for intent. Scordino and Oliver do seem to be, I often hear, what are your best cases? I actually think those two cases are our best cases because the facts of our case are very distinguishable from Scordino and Oliver.
Hey, we're waiting.
That's what
Yes.
we want to know.
First and foremost, one check versus eight times versus one. In both Oliver and Scordino, there was only one check that had been taken, cashed. I think in Oliver it was for $3,600. In Scordino it was
Why
for...
does that matter?
Well, the amount of the check has been looked at as a indicator that a person...
$33,000 in cash is a surprising transaction.
Well, for one check it would be.
Helps with an inference, perhaps, that
Correct. Yes.
That there's some
8 checks.
an inference toward the fraud that you're claiming.
Yes. 8 checks, all of them over $1,200, some of them over $3,600, 8 times. 8 times going to the check exchange. And I guess I probably should just correct, the check exchange was the check cashing facility. They did not have any information about Donna Berg, the victim. They wouldn't have been able to compare her signature to see if it does match or it doesn't.
The power of attorney and the signature card at Citizens Bank that came
Correct.
into evidence is where we had that.
Correct, yes. And if the defendant had gone to a Citizens Bank to cash these 8 checks, the Citizens Bank could have checked the signature card that they had on file and the power of attorney.
That's true in Oliver and Scordino as well. What else other than 8 checks?
8 times, well, we have the amount of the checks for one. In Scordino, it was $950. In our case, it was, in Oliver, it was $3,600. Here we have $3,400. We also have it, like I said, the 8 times is also a time frame. It was all within the month of August and within about 3 weeks. And as we've mentioned.
Do you think that alone would be enough under Oliver? Okay, so
No.
what else?
No, nothing individually is probably going to be sufficient. I think it's going to be a certain.
I thought you were going to get up and say, because you've been listening to us during your brother's argument, the memo lines.
Yes.
Don't the memo lines make a big difference?
Yeah, there are a lot of facts.
It's made out, the face of the check has the defendant's name on it.
Correct.
And then it says what it's for.
Yes. Yes.
And the defendant knows what he's done, right?
Yes. And there's
So this check was written to him with a memo line, and your brother says, well, someone else might have written the memo line.
Okay. Well, that's an inference I don't think that we need to make, and is probably not appropriate in a sufficiency case, when we should be looking at the inferences in the best light of the Commonwealth, reasonable inferences. And I'm not even sure that is a reasonable inference, that somebody would write in nursing, painting, different things in the memo line, all things that Peter Berg.
Roofing, 50-year roof, completion project.
Yeah, yes. And none of those items are items for which that the victim had need for. All of the housing expenses were included in their rent, so there'd be no need for painting, no need for roofing. And certainly we know that there was outside nursing care from the professionals, and they wouldn't have hired like Pardee, who they didn't know to do that.
The question is what the defendant knew. He doesn't know whether she needs a roof necessarily. He doesn't necessarily know whether there's an outside nurse.
Right.
What he does know is what he's done,
Correct.
right?
Yes. He probably did not do all of that work within the 3-week period in August.
Well, there's evidence in the record he didn't, right?
Correct.
Doesn't the deceased's son testifies?
Yes. Yes, Peter Berg from California came in, said that the signatures on the checks were not his mother's. He's familiar with his mother's signature.
And that none of this work was done because it wasn't required for
Correct.
where they live.
Correct.
You point to the time frame of August. Is it correct that this is a time when she was both in hospice and subsequently passed?
Yes.
And the son testified that she would have been unable to write any checks in the month of August.
Yes, unfortunately, the victim was mostly unable to even feed herself
But
in
when
August.
Justice English says, what's the list, what takes this out of Scordino?
Yes.
I guess maybe we're repeating ourselves, but I'd like to go through it again, because Scordino and all of us seem to suggest it's really hard to be convicted of these crimes, and you're telling us this case is the one case that you can. So we
Yes.
have the number of checks, the amount of the checks, the time frame of the checks.
Yep.
As I've just pointed out, her health and unfortunate subsequent death. We have, as Justice Englund pointed out, what's in the memo lines. What am I missing from that list?
Okay. Well, I think we can also look at some of the conduct that the defendant engaged in the cashing the 8 checks. For one, as we were talking about, he went to a check cashing facility. And I understand that there is a question about being unbanked and having issues of, is it better to deposit the check? Is it better to go to a place 8 times and walk out of there with thousands of dollars in cash? It's not really relevant, I guess.
Once he got the first 15 grand, he probably could have gotten a bank account.
Agreed.
I'm sorry, I don't mean to be fair.
But again, he did choose to go to a check cashing place where they would not have the signatures for Donna Berg on record to be able to compare the signatures.
You think that's a reasonable inference, that he part of his intent to defraud was to not go to Citizens and to go to a place that wouldn't necessarily trace to Donna?
It's probably not the strongest of the arguments that can be made, but I think it is a reasonable inference that as part of his conduct, and conduct can be looked at in determining what the intention is and what the knowledge
is. Was there any evidence of how much cash he actually got for these checks? Because I'm going to guess that the cash that he got for those checks was not equal to the amount of those checks.
I'm sorry, could you repeat that?
Was there evidence as to how much cash he got for the checks?
Well, I mean, other than the amount of the checks?
Not the full amount of the checks.
The full amount of the checks were
He
paid to him.
gets the full amount? The people who do the cashing of the checks don't get anything? They don't get a percentage of that?
Well, that wasn't brought into evidence, but
That's why I asked
imagine.
about, because I guarantee you that he did not get the full amount in cash. They got to make their money somehow.
I mean, they probably charge a servicing fee to do that.
Yeah,
but again, you avoid having to go to a bank and...
Well, my point is different,
Okay.
but it apparently wasn't done in this case. It would be that when you go to one of those institutions, I'm pretty sure you do not get anywhere near the full amount of the check, because their risk when they're giving cash on a check for somebody is so high. And that also could be evidence, but I don't think it was put in this case.
Okay.
Yes.
Can we get to Stephanie Pardee?
Sure. So that sounds like we're going to move to talking away from sufficiency and more into evidence. We have relevance.
What happened with the evidence? The intention was to establish that Stephanie was the niece of the defendant.
Yes. Yes.
That went south.
Yeah, I believe at the motion in limine, when the defendant was seeking to have certain testimony excluded, Stephanie Pardee, it was thought was called to testify, but it was also thought we were going to elicit testimony. The prosecutor did to show that there was a relationship between Michael Pardee, the defendant, and Stephanie Pardee, who worked for the victim, and as we discussed, I think it's a reasonable inference that Stephanie Pardee had been terminated and fired for an incident with the Bergs, which is why it was relevant back earlier in 2020 when she was terminated in February, a few months before. And the circumstances of those is that there was an employee who was driving Donna Berg, the victim, to a Citizens Bank, same bank that the checks were issued from. And
We don't know that was Stephanie, though, do we?
It was, it's an inference. It's an inference that...
Why is it an inference that that was Stephanie Pardee?
Yeah, well, there was a Stephanie Pardee who worked for the victim. There was somebody that was taking the victim to a Citizens Bank to withdraw large sums of money, and then that person was terminated. And it was a convoluted exchange at the trial as far as getting that evidence in.
That seems to me to be an inference that is beyond what one could reasonably draw. The fact that these three events occurred without any nexus between them. In the evidence, there was no nexus between them.
Yeah, no, in what was elicited at trial, but there was an intention to bring this evidence out. So at the time that the trial judge was ruling on his motion in limine, there was that expectation, which would make it very relevant. And again, on relevance grounds, the testimony, well, we agree was highly relevant. All of the testimony regarding Stephanie Berg, it came in through Stephanie Pardee. It came in.
Why was it at all relevant without drawing the nexus that she was his niece? That evidence never came in. So we've got this name Stephanie Pardee,
Yes.
which sits alone, potentially prejudicially.
Yes. Correct. Well, we believe it would have been.
Why was it relevant?
It would have been proper rebuttal evidence to the defendant's claim that perhaps somebody else other than the defendant stole these checks and cashed these checks, and what the intention.
And did the defendant, your brother says that argument wasn't made. When was that argument made?
It was brought up in closing arguments as a suggestion and even an opening argument. I believe I highlighted that in the brief on trial. Was it the transcript, page 17? Hold on 1 second. Yeah, there was, just give me 2 seconds.
So the defendant adverts in opening to the fact that there might have been a third-party culprit.
Yeah, I believe the suggestion was being made that somebody else, an employee perhaps, would have had access to these checks, and perhaps it was that person.
Yeah, but who put
perhaps
in...
Stephanie Pardee, I think, was the trial counsel actually did say perhaps it was even the crook, Stephanie Pardee, did this. And
defense counsel says that in the opening.
But yeah, and I mean, it wasn't elicited in testimony. It was from trial counsel, but it was an indication of where they were heading.
Okay.
Yeah. Are there any further questions?
I just want to clarify, the defense below was identity, and on appeal, he's raising for the first time intent to defraud, yes?
Yeah, knowledge and intent, yep.
Do you take the position that he can't do that? It's a sufficiency as to an element of the crime, right?
We would still review for substantial risk,
Correct.
right?
Yes, and even doing so, even under the more forgiving standard, we believe it was met sufficiency. So, thank you, Your Honors. Thank you for your time and consideration.
Thank you. The case is under advisement. The last case we're going to call before the break is Commonwealth versus Justin Page, Docket number 24P298.
I won't be able to talk. Thank you.
Good morning, Mr. Crane.
Good morning.
When you're ready.
Good morning. May it please the court, Edward Crane on behalf of Justin Page. The issue in this case involves the scope of the community caretaking exception to the warrant requirement. If the exception still exists in the wake of Coniglia, the question here is whether the scope of the exception extends so far as to justify a warrantless search of a person's backpack. It is the defendant's position that it does not. At best, the Supreme Court has ruled that the exception applies to an inventory search of an impounded vehicle. The SJC has not gone much further, as it is ruled that the exception applies to cover a brief detention of an individual. Neither
We
court...
have to look at this as a, we don't, right? We could affirm on any ground raised below and supported by the record,
Yes, Your Honor.
which would include emergency aid, right?
Yes.
Okay. Keep going on the community caretaker issue for a while.
Well, with respect to community caretaking, I'll say that neither the Supreme Court nor the SJC has ever ruled that the exception would extend this far to a warrantless search of a person's belongings.
In your reply brief, you did a wonderful job of saying this might be something the SJC has to decide on further appellate review.
Yes,
Should we really go there? I mean, if we don't have to decide the issue, why wouldn't we decide it on emergency aid? And then you've preserved your rights. The second floor can address that as they deem fit.
I'm happy to get into emergency aid, and I think it's important just to be clear, though, as well, that I think the argument that the community caretaking exception doesn't exist under the Fourth Amendment, that's something that this court can't rule because the SJC has recognized the exception. But what
And you've said that, and I appreciate that.
Well, the Supreme Court doesn't say that in Coniglia anyways. They say that it doesn't apply to our residents.
True.
They don't say that it doesn't exist anymore.
Not that I would ever, really debate Judge Meade on a question like this, but do they actually say it doesn't apply at all in a residence context? Because Breyer, Roberts, Alito, Kavanaugh, that all seems to suggest that something applies in a residence context, right?
Yes, and I think that some of it's implicit, but some of it's expressed, that their preference is that the emergency aid exception should be the doctrine that's applicable here. And I think that part of the reason the court probably even took the case in Coniglia is they're a little baffled by this creation of the community caretaking exception. The Supreme Court has never, to your point, the Supreme Court has never said that it does not apply outside the context of the home. But they've also never actually acknowledged its existence in the first place. Even Katie, I don't think, where the exception derives its
Is there
origin
room
from.
between the Roberts, I mean, this is perhaps, I'm sorry, maybe I'll get us off track, but Roberts gives the hypothetical of the elderly woman who doesn't respond isn't it reasonable under those circumstances? The only question we're talking about is reasonableness, right? The reasonableness of the search. Isn't it reasonable under those circumstances to enter the home? That's the position taken. Do you think that the majority opinion rejects Roberts' hypothetical as a reasonable basis to enter a home?
No.
Okay, but you think it's under emergency aid?
I do believe it's under emergency aid, and
But then you can't take a really narrow view of what emergency aid is.
well, I think that my interpretation of emergency aid under the SJC's precedent, and particularly under the case Commonwealth v. Kapler, is that it involves two prongs. Number one, is there an objective reason, a reasonable belief that there is an emergency ongoing? And then number two, that the police
That's
action...
exactly what I mean. So you in your brief make these arguments that there's narrowness to emergency aid, but in the hypothetical of the 80-year-old woman who hasn't responded for a day, would you say there's an objectively reasonable belief there's an emergency? or simply that it would be reasonable for the government to enter that home under the circumstances? You understand my point?
I understand your point. I think there would be an emergency in that situation. An
Okay.
elderly person that hasn't.
All right.
The appeals
Well, then
court.
let's take that to the facts of your case. This guy is, you concede there's an emergency going on,
Yes.
apparently overdosing, and he keeps reaching for his backpack over and over again. It's not reasonable to look in that backpack to see if there's something in there that could be used as a weapon?
No, not with no real basis to believe that there's something, that there's some weapon in there. And I think it's important, too, to note that the second prong of this is that the officer's action has to be motivated. They have to have the intent to alleviate the emergency. It has to be connected to the emergency
Well,
itself.
that's an incredibly narrow view, and that's actually not what the cases say. As I read them, they say once there's an emergency, they have to act reasonably in their entry on the other person's property, or, in their entry on the other person's property.
Well, I think that's why it's critically important to look at this Kapler case from the SJC, where you have this entry into a home, and there's a seizure of a tequila bottle. And the question ultimately is, should the tequila bottle be suppressed, or was it validly seized pursuant to the emergency aid exception? There's no question there's an
Majority
emergency.
found that the emergency had dissipated because the person who was in the home had been taken to the hospital. Justice Cordy says, I don't think the emergency's been dissipated, so I disagree. In our case, had the emergency disappeared at the time that he looked in the bag?
No, but I think Kapler stands for more than that. It looks to the police intent in saying, it even states that if the officers had recovered the tequila bottle with the intent of trying to derive some sort of treatment for the individuals who are sick, then that would be, well, it didn't conclusively say that, but it certainly implicitly implies that that would be covered by the emergency aid exception. But it's because their intent in seizing the bottle, the Commonwealth failed to establish that their intent in seizing the bottle was related to alleviating the emergency, that the doctrine didn't apply.
Can we follow that reasoning down the path to this case? Let's assume that subjective intent matters, even though, and I know there's case law in this Commonwealth that suggests it does, but it's a rarity in Fourth Amendment law that subjective intent of the officers matters. But let's assume it does. Here he said, I looked in there because I was worried there was a weapon. And you say that's not a basis because why? It wasn't reasonable to think there was a weapon there?
Yes, I mean, the emergency here is the overdose. If he's looking in the bag.
That doesn't.
Andy's behind the wheel of the car.
And they said they wanted to not just were concerned about a weapon, but to find out what his identity is, which might give them more information to help dissipate the emergency.
Well, he did find that the officer's intent was to look and see if there was a weapon in the bag, and also to see if he could identify the defendant. There's nothing, though, in the record that, or at least in the judge's findings, that would indicate that the purpose of the search, the intent in searching, is to alleviate the ongoing emergency of him overdosing.
He's behind the wheel, overdosing, and continuing to reach for a backpack. Like, what? He's not in his right mind, right, because he's overdosing. Why is he reaching for the backpack? That, to me, suggests not just officer safety, but his own personal safety, and he was in a parking lot where there were citizens that could have been at risk as well. To me, it's the act of him continuing to go for the backpack that causes me the greatest alarm.
I guess I don't see any evidence, though, objective evidence, that he could
He's
rely
not
on.
reaching for Narcan, right?
Doubtful. But I don't see any objective evidence here that would support the officer's belief that there's a weapon in the backpack. And if there was...
Does it have to, I mean, he says that, but why wouldn't it be objectively reasonable to search in the backpack that he's reaching for to perhaps see what he's under the influence of that will assist the EMTs in caring for him?
And I think that's an important distinction. And if he had said that, if that's what he said his purpose was.
It's objective, though. Forget about what he said.
I don't think you can look at it objectively. I think that Kapler case does indicate that it is ultimately the purpose that motivated the police conduct that is critical to the application of the emergency aid doctrine.
Here's what the judge says. This is at Record 21. Here, the scene was active. Deputy Chief Gordon believed that defendant was suffering from an overdose while defendant repeatedly attempted to grab the backpack and the steering wheel. Deputy Chief Gordon reasonably based his seizure of the backpack upon both the need to ascertain defendant's identity as well as for the safety of the public, the officers, and the defendant.
And I guess my disagreement with that
None
is...
of those findings are clearly erroneous, right? You don't disagree that he was suffering from an overdose, he was trying to grab the backpack, he was trying to grab the steering wheel. The location was where it was so that there were people, both police and civilians, around. They didn't know who he was. None of that's clearly erroneous. So the legal conclusion is what you're challenging, that it was reasonable to, I guess, I understand why you're saying it wasn't enough to justify a weapon. What about his ID, to ascertain who he was?
Well, the findings on that aren't clear as to what the purpose was in terms of him obtaining the identification. Was it to obtain the identification so that he could somehow obtain knowledge about the defendant's medical situation, and maybe that would help them deal with the situation? There's nothing other than just the fact that I wanted to know who he was.
Right, which, what are they going to do? They're going to take the name and they're going to run it through their databases, which I think could include, potentially, finding someone who knows this person.
Because that's a finding that wasn't made. I mean, that's outside
No, but
of...
what was made was, what was found was that part of his intent was to get an ID. The purpose of getting the ID is to run it through the databases.
Can also be to identify him because they suspect he may be up to criminal activity.
Which would require running it through the databases.
So the Commonwealth cites in the community caretaking function line that an officer may take steps that are reasonable and consistent with the purpose of the inquiry, even if those steps include actions that might otherwise be constitutionally intrusive. Knowles is the case. Mm-hmm. So they're performing the community caretaking function, and then what otherwise wouldn't have been a lawful search based on reasonable suspicion, that they otherwise do something that might be constitutionally intrusive. Why isn't Knowles answer the question here?
Well, I would say first off on Knowles is a case that, to me, indicates that subjective intent is relevant, because reading Knowles, the court does focus on sort of what motivated the officer to conduct the investigation in that case, and they do note that his actions are more akin to someone who is investigating a crime. And I think with the community caretaking exception, part of the problem with the whole exception is I'm not sure how to apply it. I don't think there's a clear standard for it, and there have been plenty of courts and commentators, and even Justice Sotomayor at the argument at Caniglia was basically like, I don't understand how to apply this because there's no clarity with respect to the standard. And I see in the case law, certainly a lot of that language from Katie is quoted and repeated, but I'll be honest, it seems to me like fluff. It doesn't actually tell us how the standard is applied. With most...
Everything we have in the Fourth Amendment area comes from one word: unreasonable. Everything we have. And, unreasonable is a word that requires a lot of definition and thinking, but the problem that you have, it seems to me, is if the police get a call that says there is someone in a car who appears to be overdosing, okay, they got to go. And it's not an unreasonable search to go inside that car when they're trying to help somebody who appears to be overdosing. We can't construe the Constitution to say they can't do that. And I don't know, there may not be any agreement on this panel, but
I'm sorry.
well, I was just going to make the observation that if I'm in that car and the guy's reaching for a backpack over and over again, I don't know what's going on, and I'm a police officer, I might be concerned that he has a weapon in there. And I don't have to do my job and not take reasonable, the word is reasonable, steps to ensure that I'm not going to get knifed.
You know, I just think that that's a hunch, though, the idea that he has a weapon. And if we're strictly are looking at it in reasonableness, I don't quibble at all with, of course, going into the car, assisting him, I think removing the backpack, totally reasonable. It's searching the backpack.
But they have to give him back the backpack because he's not committed a crime. So then he's got it with the EMTs.
Right, he's going to go in the ambulance with a backpack, potentially. He doesn't in this case, but if he had to go in the ambulance, he's got a zipped backpack with EMTs, as it turns out, with a loaded gun in it.
I think the reasonable thing to do would be to remove the backpack until that determination is made as to whether, is he going in the ambulance or not. He ultimately doesn't wind up going in the ambulance.
So that's an argument that the actual Fourth Amendment violation was looking in the backpack when he looked at it, not that he could not have looked at it before sending him away in an ambulance.
Certainly, and all Fourth Amendment issues involve timing of a nature. When police know more information, things become more reasonable.
But we also have to make rules that the police officers can follow without tripping over fine distinctions, don't we?
Of course. And I think that's a problem that I'm sure that you all will grapple with for the rest of your careers, trying to draw those lines. But
We'll grapple the rest of the afternoon.
Fair enough,
Ms. Meade has another question.
You're not saying that when the police are acting under the emergency aid exception or in the community caretaking function, that they're to ignore suspicion of criminal activity. Is that what you're saying? Because that doesn't address the community care or the emergency at issue. Because let's be frank, the reason we have all of these cases is because they result in the discovery of criminal activity.
yes.
So that can't be the rule. They have to ignore criminal activity when they're exercising an emergency exception.
Certainly, they do not have to ignore criminal activity. That's absolutely not the case.
And what about safety issues?
And of course, they can't ignore safety issues. But I do think what it comes down to in terms of at least implying the emergency aid exception. Community caretaking, I can't wrap my head around how to apply that one. But with respect to emergency aid, I think the motivation, the purpose behind the conduct is critically important. And I think that distinction between the Kapler case and the McCarthy case is really informative with respect to the facts here, because Kapler, again, the court really focuses in on what motivated the officer to take the tequila bottle in that case. And because it wasn't for the treatment of the ongoing emergency, the two individuals who were sick, the court said that this wasn't within the scope of the emergency aid doctrine. Then McCarthy, you have the opposite, a very factually identical situation to this case, but the officer acted with the purpose of trying to alleviate the emergency. I think that's the distinction.
We're going to leave it there. Thank you, Mr. Crane. And Attorney Lynch, if you need additional time, because we did go over, I'm watching the clock.
Thank you.
Thank you, Your Honor. Hoping I won't need that time, but thank you for the consideration. May it please the Court, Assistant District Attorney Bethany Lynch, representing the Commonwealth. I'd like to take just a brief step back and address an issue that I raised in my brief that we haven't discussed, and it's the fact that this was a conditional plea, and the plea was conditioned on the issues raised below. It was conditioned on the judge's findings in the motion to suppress and the motion to suppress hearing and the issues raised therein.
You say the constitutional challenge was not raised and therefore not preserved.
Exactly. So I argue that that is not before this court properly.
Your argument below wasn't based on the community caretaking function. The judge raised that himself.
He did. I would suggest to this court that that to draw a bright line rule between community caretaking and emergency exceptions is a difficult line to make, and that the judge used community caretaking and emergency almost interchangeably in that they represent the same.
But I don't understand your argument, I have to say. On this point, this sort of, the conditional plea, I thought the conditional plea was that he reserved the right to appeal from the decision that denied the motion to suppress.
Yes, based on the challenges that he made below. The motion to suppress was denied,
his
but
challenge, as Judge Meade points out, his challenge below would not have addressed the community caretaking function because you didn't raise it.
Well, we raised it as.
You argued emergency aid. So
yeah,
he's not in a position to even know that the constitutionality of community caretaking is at issue below.
He was when he got the judge's ruling, and he didn't look for any kind of reconsideration.
And he says, I'm reserving the right to challenge the ruling. Isn't that, and what's the exact language of the plea? It's, I'm reserving the right to challenge the.
Yes, to challenge the decision.
Okay.
But I would suggest that in order to challenge the decision, it has to be a decision based on an issue that the defendant raised, and he did not raise this issue. So he can't, you can't raise new issues before this court about the constitutionality of I'm not talking about the application of the caretaking function. I'm talking about the caretaking exception. I'm talking about the constitutional.
His argument below was the search of the backpack was unconstitutional. That was his argument.
Yes, generically it was unconstitutional.
And the judge said, no, it's constitutional because community caretaking function. And he says, I reserve the right to challenge the ruling. I really can't understand the argument. In this case, I can understand the desire of the Commonwealth not to be surprised by the arguments that are being made. And maybe part of this is the Commonwealth feels surprised by an argument that basically says, we want you to do away with the community caretaking in the Commonwealth. I get that.
Precisely, Your Honor. And the fact that it's not limited, like if you can say it was unconstitutional and that somehow preserves any constitutional challenge, I understand that in this case it may not have been specifically set forth by the Commonwealth in its arguments, and perhaps he says he didn't have knowledge that that might be the basis of the decision. But in this case, we went from a motion to suppress having to do with a backpack to now he wants this court to address the entire constitutionality of the community caretaking function based on a Supreme Court case that was in existence at the time. He didn't raise that as a potential. He said there was no exigency. He didn't claim that the community caretaking function would not have applied. So my argument is that because it was not set forth in the motion to suppress or in the agreement for the issues raised on appeal, that this is not an issue that the Commonwealth, in its agreement to enter into a conditional plea with the defendant, was considering as part of that negotiation.
Do the federal circuit cases under Rule 11 of the federal conditional plea, do they require issue by issue?
They do. They require you set forth the issues, and even if other suppression issues are available to the defendant, if he does not raise them or if they are not addressed by the motion judge, then they are outside the scope of the conditional plea, unless the parties agree to, the language is important.
What if it's just a question of law that need not be developed with any factual basis, other than what's apparent in what in the case? I mean, they don't. Unlike raising a Miranda violation for the first time on appeal.
Well, I would suggest that in order for that it's not strictly a question of law because of the application to the facts in this case. In theory, the difference between Coniglia and the facts of this case. So I think that there is an application issue where the facts of the case are relevant. It's not just whether the motion judge can't.
I'll overly simplify what Mr. Crane has said, as far as I understand it, is that the Coniglia court says that the community caretaking function is a dead letter.
Yes.
Yeah. So I don't need any fact, if it doesn't exist as a matter of Fourth Amendment law, I don't need a factual basis to
I mean,
attack that.
that's true, but I would suggest that that the motion judge, that should be something that is before the motion judge before it is.
I totally
before
agree. It would
this-
have been helpful
this
to
court.
see what the motion judge says, but we'd be reviewing that de novo anyways.
You would be renewing it de novo. But again, I think of an issue, and especially an issue of this magnitude, to be put into a conditional plea appeal without there having been any discussion of the matter whatsoever below is beyond the scope of what conditional plea and appeals that follow are designed to do. It's designed to limit the issue rather than expand it. And if
And you, I'm sorry to interrupt you,
No.
but the idea is that you've done some charge bargaining. You've
Absolutely.
dropped 3 gun charges.
yes, there were major charge concessions in this case
And based on that,
and sentencing.
you're
as well.
looking for the benefit of your bargain that wasn't outside the scope of the agreement.
Precisely. That's the point, that I just want that before this court to let, so that our Commonwealth's position is.
Are there any Massachusetts cases since the adoption of this rule?
It's new, so I don't have a Massachusetts case. I cite cases based on on the federal rule upon which the Massachusetts rule is based, and the language is
You
remarkably
say that
similar.
we're to interpret it under the Rule 11 cases, but they said it in the interim, and then they.
Right, and then they passed, they amended the rules of criminal procedure to put 12b-6 in, and since then, we don't have, to my knowledge, any case law on this point having to do specifically under our Rule 12. So I looked to Rule 11, I believe, under the federal
something, yeah.
system, because it was based on the same thing. And
Unfortunate they chose to make it 12b-6.
I know.
And Rule 11.
In Rule 11. And also briefly, just on the community caretaking function, this Supreme Court, I would suggest, even if you did reach that, the Supreme Court did not completely eradicate it, and that it does still exist in Massachusetts. The Supreme Court has not gotten rid of it. The Supreme Judicial Court has adopted it. So it was a function or an exception that the motion judge was available to him, fully available to him to apply. And in this case, I would suggest that it wasn't. It's not that difficult of a concept to apply. It has to do with a wide range of activities on community caretaking, and to this point, we did have the emergency as well. So that's what I'm arguing, that it is in a way a hybrid, because as the situation developed, when the police first arrived, the defendant they were called to the scene by passersby seeing him in a parking lot. He's unconscious, he's unresponsive, he's gray in color, he looks terrible. So they call the police.
And he's behind the wheel.
And he's behind the wheel of a car in a parking lot with many open businesses on, I believe, a Sunday afternoon. And in this case, an off-duty police officer and his off-duty police officer wife were just going to the grocery store in that same plaza when they heard the call. So they responded immediately. Chief Gordon he responded. He doesn't do any investigatory work, and so he actually had his wife go, and she's the one, because she's still an investigating and street officer. She went to assist the defendant. She got the car door open, does a sternal rub, brings him back to some level of consciousness. He is combative. He is reaching for this bag, and it takes multiple officers to get him away from the bag.
Why
and
is it
everything.
reasonable, sorry?
What justifies the search in the backpack?
I would agree with the motion judge that the search is justified by his fear that in reaching for that backpack, there could be a weapon in there, because he is reaching for it very forcefully. And again, he is combative with the officers, and his hand is near the wheel, and it's near the gear shift, and he's reaching for the bag, and he doesn't know.
I'm sorry, does it have to rise to the level of a reasonable suspicion that the backpack
I don't believe so, no.
has a gun?
It has
Why?
to be an objectively reasonable belief that the action that he's taking is in a way protecting public safety. That's or responding to the issue.
That Kepler versus McCarthy subjective, objective, where do you fall on that?
I fall on the fact that the subjective belief of the officer is not, it's something that you hear through the testimony. The officer here did testify as to the reasons that he subjectively did it and what he thought, but the standard for this court to apply is whether it was objectionably reasonable. So his subjective belief is put to the side, and whether it was...
That's not what the cases say, though. That's not what Kepler says. Your brother's right about that, isn't he?
But
Look, maybe I shouldn't be quite so forceful, because it seems to me to be bad law to be talking about the subjective purposes of the officer that they are able to articulate maybe a year after they did this. But, if you look at Cordy's dissent in Kepler, he uses the words objectively reasonable like 4 times.
Yeah.
And the court also uses the words objectively reasonable, the majority opinion. But they seem to be saying, look, in fact, there's this passage that I read this morning. If you had said you were looking at that tequila bottle to find out what kind of drugs might have caused this, it would have been okay.
Yeah.
Or it might have been okay, I think is what they say.
Yeah.
Right?
Well,
so what do we do with that?
The case law, like I have the case of McDevitt, it's an appeals court case in this 57-733, that the subjective nature of the officer's beliefs is not part of, it can be part of the information, but it is not determinative. And so if...
That's McDevitt, what is that? That's one of our cases?
It is
Decided
one of the cases.
when?
Yeah.
2003.
I was going to say 57 is I didn't have the year written on my notes, but
So that predates Kepler, right? Kepler is like
Yes,
2014
it would predate, but-
or something?
But I just think that relying entirely on the subjective opinion of the officer is not what jurisprudence tends to do in these cases, having to do with motions to suppress based on these constitutional issues. All of the various types of challenges, they deal with the objective nature of the situation and what a reasonable officer would do or a reasonable person would do. So while, Kepler, maybe the officer was so blatant about it that maybe there was no real way around it, but in the cases upon which I would rely, of course, in this case as well, the subjective nature of the officer's actions
Trying to do is
the
distinguish
same.
between acts that could be identified as investigatory acts.
Absolutely.
And acts that really are community caretaking
Yes.
or responding to an emergency,
And-
right?
yes.
And what the cases are sort of trying to say is, look, if it looks like you're using community caretaking
Mm-hmm.
as a pretext for what is really an investigation, we're not going to let you do that.
Yes. And in this case, the judge credited Deputy Chief Gordon's testimony that he was not investigating, that he's not an investigator, and that he wouldn't have done that anyway because he's just arriving on the scene as an unarmed officer just at the scene. He would have waited for any investigation anyway. So he credited the officer's testimony that he was not engaging in an investigative function, that he looked in the backpack for safety reasons and to
Does he
identify
actually make
the
that
victim,
finding
the defendant.
as
I'm sorry?
a finding? He credits the testimony that it wasn't for investigatory purposes
He
as a
credited his
finding?
testimony as a whole,
Yeah, no, he didn't.
and he testified. I'm sorry?
Okay.
He credits his testimony, but he doesn't make that specific finding. He credits it as a whole.
No, he credits it as a
Yeah.
whole, and that's what he testified to. But he does say, I believe more than once, that he credits his testimony, and his testimony was, I wasn't investigating anything. I was looking in the backpack because I was afraid there could be a weapon in there. He's reaching for it. I have lots of civilians and other officers around, and at the time that this happened, it was before the ambulance got there, and the defendant was still in some type of medical distress. And so the officer, Chief Gordon, thought that he was going to go in the ambulance, so he didn't want to send it in the ambulance. He wanted to identify the person. And those were the reasons upon which the motion judge based his finding that it was reasonable.
He also said, Gordon said he wanted to find out the defendant's identity.
Yes.
I espoused my supposition earlier, but tell me how does learning his identity help the circumstances here?
First, it would have identified who the person was. It would have, potentially, if they ran his name and they had seen some other drug activity on his record, they would have been more likely to believe that possibly it's a drug overdose if he has past possession cases. Because they did believe it was an overdose. The testimony was they believed it was an overdose, but that it could also have been a diabetic issue or a seizure. So they wanted to be as careful.
Some of those
yeah.
things marked on an identification? If someone is an epileptic, is that marked on their ID?
I don't know. I don't know. I think he was just trying to get the information, plus if
But your
in,
license is pulled if you have seizures within 6 months, right? So that would show up on the RMV log.
I'm going to take your word for that. I didn't know that. But he also was going to be going in the ambulance and for medical care. And so identifying him for those purposes as well, I would suggest it was objectively reasonable for the officer to look in the bag. And then once he looked in the bag, he saw what he saw.
Before they let him get in an ambulance any more than before they let him get in the back of a cruiser, wouldn't they have to search his bag to make sure?
I would say yes, and there's the recent case from this court from, 2 weeks ago, Demos D, about putting a juvenile in the back of a car. And that is a community caretaking case that it's reasonable to search someone before you put them in the back of a cruiser to make sure they don't, even if there's no necessarily suggestion they have a weapon.
Pat frisked them.
Like,
Also
yeah, like-
search any of their closed containers?
If they had one with them and you were going to put it in the back of the
Is that what
cruiser
the
with
case
them.
says, though? Does
It
the case
doesn't,
deal
it
with
doesn't
closed
extend
containers?
to that. It doesn't. It extends to searching the person because he didn't have a bag.
Does McCarthy hurt or help?
I think it helps, only in that it was allowing, well, I don't know that it does one way or the other,
They
because
searched her purse,
they
right?
searched her purse specifically at the request of the EMTs to see if could we find out what she's overdosing or what she took. The purse was well out of her arm's reach. So in that way, it doesn't really speak one way or the other, because even if she was reaching for it, she couldn't have gotten to it. So I'm not sure it really helps. Factually, it's similar in that it's responding to an overdose and it's searching a bag, but beyond that, I'm not sure it helps the court one way or the other.
You did use some extra
Yeah,
time.
we endeavored
Did
to
I?
make you go
Oh.
over.
I had one more. What do you make of your brother's argument that it might have been okay to look in that bag just before he went in the ambulance, but it wasn't okay to look at it when he looked at it?
I think that in this fluid situation, I think that the ambulance was one factor the officer's thinking, if he's going to take this with him, I want to make sure there's nothing in it. But he also was so forcefully reaching for this bag in a contained area, but there were civilians all around. So were there some sort of a weapon? There were multiple officers trying to get him out of the car. So I think that the timing of it, had they done it right before he got in, I think that would have been fine as well, but I don't think it's detrimental that they did it right at the scene, because that's when they perceived the threat the strongest.
This case is now under advisement. Counsel, I want to thank you both for excellent briefs and
Thank you.
excellent argument.
Thank you.
We are going to
Yeah,
take a
agreed.
brief morning recess, and when we return, we will hear the McCarthy case. Not the McCarthy case we just talked about, a different McCarthy case.
All rise.
Yeah, I mean,
Yes, that's fine. Great. Welcome back. We are going to proceed with the next case on the list, which is Jeanette McCarthy versus Arthur McCarthy, docket number 24P425. Attorney Lundy, I believe.
Yes, good morning, Your Honors. May it please the court, Sandra Lundy for the appellant wife. We know that the judge's factual findings are viewable for clear error, and I'd like to plunge in here now with one factual finding that the judge made that's clearly erroneous and that's central to her asymmetrical division of the marital property, the ESOP and the SARS accounts. And you find that finding at finding number 92, 92, in which the judge said that the marital partnership was basically over when the couple stopped sharing a bedroom, and that event occurred sometime several years before the actual filing of divorce. To understand how critical this finding is to the judge's
where exactly in the findings are you pointing us?
at paragraph 92.
Paragraph 92. So the court finds that the parties' marriage had been broken down for several years prior to their separation.
Right, and then if you look at how critical that is to the judge's analysis, if you look on page 20 of the judge's memorandum, the judge says, and I quote, "The parties made relatively equal contributions, albeit of a different nature, to the marital partnership up until the last few years of the marriage, and the property division at the time of judgment reflects that." The property division at the time of judgment reflects that. There are a couple of issues with that finding and with the rationale. First of all, we don't know what couple of years the judge is talking about, but we do know that that somehow factored into the McCarthy analysis. How did that happen?
But can I stop you and ask you, is it your position that the statement, the parties' marriage had been broken down for several years prior to their separation, is not supported by the record to the point where we should find it clearly erroneous?
Exactly. That's exactly my point.
So it's not supported by the record at all? Because didn't the husband, I mean, the judge makes a reference to the husband's testimony, at which the judge credits on the fact that the marriage had broken down.
The judge makes the inference that the fact that they stopped sleeping together in the same room
I'm not sure that that is what the judge is inferring.
But I think that what she's saying is that's when the financial partnership ended as well. And that's not what the facts say. Because if you look at the facts,
But that's also not what this says. It doesn't say that's when the financial partnership ended as well. It simply says the parties' marriage had been broken down for several years prior to their separation. It also says, and their physical intimacy was non-existent during that period.
Right.
You want to take the second phrase as being the only basis for the first?
I think it depends on how you look at what breaks down in a marriage. You know, we know from Openshaw and other cases that a marriage, and Savides and Savoy case that I quote, a marriage is more than just the physical or emotional intimacy in a couple. It can also be their financial partnership.
But
And the
Attorney
evidence...
Lundy, you know I have a little experience in this area.
Yes, Your Honor.
I don't think it matters, in the sense that virtually every complaint for divorce has a date on which the plaintiff alleges the marriage broke down. Sometimes it's the day they file the complaint. Sometimes it's years earlier. I think the marriage had been in trouble. I think I agree with Justice Englander. I'm going to rephrase it. I think you're reading into finding 92 something that's somewhat unnecessary, because if we're looking at the property division, and I don't like the use of the word spirit of the Bacanti time rule. I once used the term spirit of something as a probate court judge, and the appeals court told me not to do that. But if you look at what the judge did on the asset division, it's rational. I might have done something different, you might have done something different, but as I'm not as concerned about having a denominator and a numerator and when did the marriage break down, because I read the division of the ESOP and the SARS as really about when he earned them, the fact that after their divorce, he's got to get up every day, breathe, go to work for them to vest and get paid out. It was a staircase down, and we do staircases down in assets that are to be treated on an if, as, and when basis all the time. We said it in Canisius versus Morgenstern that neither side, I believe, quoted in their briefs. It's not uncommon when you have assets of this nature. I think the Bacanti spirit of the Bacanti time rule is a red herring in all this. She had the power, if she wanted to do a modified Bacanti time rule. She didn't do that. If I excise from her decision all discussion of Bacanti and just look at the timeline, this is a staircase down that's rational, that flows from the facts. Whether the marriage was over or not at any particular point in time, she still is getting a piece of something that has yet to be realized on a stepped down basis. It makes sense to me. It's equitable. It may not be equal, but it's equitable.
It is, I would respectfully disagree. If you look at the documents, if you look at the ESOP document, one of the things we learned at the ESOP document, remember this was a 31-year marriage. She was 60 years old when the couple divorced. And the ESOP was particularly granted in Mr. Casey's testimony to help reward people who made the company what it was.
Absolutely, he was a key employee, no
right.
question.
Now, under the ESOP, the mandatory the normal retirement age, this is on page 99 of volume 2 of the record, is 65. So that's 5 years versus the 17 or 15 years. Mm-hmm. And once a participant, I'm reading from page 100 now of the file, if a participant attains normal retirement age while in the employ of the company, the balance credited to his or her account will be fully vested and will be distributed to him or her. So the judge ordered basically a radical step down of the number of years, when the fact is that when he's 65, and she found that he was fully capable of working to 65, as long as he's healthy, and...
Right, but he doesn't have to. He could decide, he's not married anymore, and he's 60 years old. He could say, I'm going to change my life, right? And your argument for why your client should get 50% of this, even though 50% had not vested, even though 100% had not vested as of age 60, is essentially that because he's healthy, he's going to work till he's 65.
I'm sorry, Your Honor, that wasn't my argument. The judge could do 50%, as I said in my reply brief. It doesn't have to do 50%, but the radical asymmetry of the award that she did make is, I believe, an abuse of discretion.
It goes 35, 25, 15, right?
Excuse me?
35, 25, 15. None of it had vested as of the time of divorce.
But all of it would vest in 5 years.
If he
So what do you
continued to
say
work.
the percentages should have been?
Honestly, I don't know, but I know that the 15%.
So this is wrong, and it's not necessarily 50.
Well, I mean,
This is her discretionary call.
Right. And the issue is, in the circumstances of the case, does it leave you with the conviction that there was something inequitable about the way it was distributed?
But it was an abuse of discretion. Isn't that the standard of review?
Well, that is the...
Beyond the realm of what she reasonably could have gone to, have decided.
That's Correct, because it was, first of all, it was founded on an erroneous finding, and secondly, it
And the
gave the...
erroneous finding is, again, what you pointed us to in 92, that the marriage had ended earlier?
Well, that's one of them. She repeats that.
Because, you know, let's just assume that's out. He still had to work for 5 years for these things to vest.
Right, so he worked, so let's say 20% of the, let's say three-quarters of the entitlement to the SARS and the ESOP was formed within the marriage, and then he had 5 years left, so maybe that's half of 75%. But I don't know. That's what I would think is reasonable here. But to say that there's she has 15% of an asset that within 5 years, and remember, and I'm not saying that it shouldn't be an if, as, and when. I mean, that's a given. That's a given. But in 5 years, he walks away with an enormously more greater share of this asset that was created during the marriage than she does. Is that equitable?
Created in 2014, right?
It was created, the ESOP was 2014, but remember, the purpose of the ESOP is to reward the efforts of the employees that it took to get the company to where it is. All of that happened during the
Attorney Lundy,
marriage.
the clock is ticking, and I actually am far more interested in the alimony question.
Okay.
Are there any cases that do an average of this many years of alimony? Putting aside the hybrid self-executing piece of it, I'm particularly focused on her use of a 15-year average.
I have not found a 15-year average.
What's the most you have found?
I found, I believe it's a Davai case, I don't know how to pronounce it. It was 10 years, and the judge threw out the top and threw out the bottom, and there was 1 year that was not accounted for because the parties didn't present evidence.
Why do you say she does a 15-year average?
Because that's what she does. She finds...
Do a 15-year average, what would you come up with? What number? If you
She
took
comes up with
15
$209,000 as the marital, as the average marital.
But I did the calculation that showed me that if he made $320,000, she'd get 30%.
Well, we're talking about base, right? We're not
We're
talking about the percentage of the bonuses.
Right.
We're talking about the base.
Right, and what happens when you do that averaging is that you put much more weight on the beginning than on the...
Not the base. The numbers that come out to 209 is both the base and the bonus.
Right, it is with the base and the bonus, that's correct.
Right, so don't we have to think about it in terms of base and bonus? The person is, the judge is trying to come up with what's the right number for this. A big chunk of his revenue, his income was bonus, right?
Right.
Pretty good sized chunk.
But okay.
Every year.
And that, I think, goes to my point, because the judge just focuses on setting the base alimony on his base salary and her base salary, whereas the judge also found that the husband's salary was bonuses were used to fund the marriage for the entirety of the marriage, and she also finds.
But this is my difficulty with it.
Sure.
Is what I just said, which is, I ran a calculation. If he made $320,000, she would get 30%, which is within the range, right? So I'm having trouble understanding why this alimony award is an abuse of discretion.
Well, there are a couple reasons. One is that that she basically keys the marital lifestyle to the average, which doesn't reflect...
320 isn't the average. 320 is $100,000 over the average.
No, but she said that her alimony order is intended to allow the wife to live at the lifestyle that she lived predominantly throughout the marriage, which I take to mean that average 2009 figure. The other issue...
That's not the way it works. I mean, so first of all, she gives two significant concessions on alimony to your client. Number one, she doesn't assume that your client could have any imputed income beyond what she's making at 15 hours. And then she says that the husband has to continue to make payments as long as he's working. They don't end at whatever it is, 66 years and 10 months.
Retirement age.
Right? So there's two concessions to your client, and then she sets up a scheme that says, well, she gets 32.5% of a certain number, which I think is 209, and then she gets other percentages of the bonus. And I just ran the numbers, and at $320,000, your client's within the range. I'm having trouble understanding what we're fighting about.
Well, one of the things we're fighting about is how she set alimony in the marital lifestyle. She looked only at consumption of goods and services. That wasn't what the marriage was about. If you look at...
Let's rephrase it. She didn't do the here and now, is what you're arguing.
She didn't do the here and now, but she also, if you look at finding 96, she said the parties' joint focus during most of their marriage was to provide a home for the family and to invest in their retirement. The judge based her alimony solely on what the wife needed so she can spend.
Was that argument made? That's Openshaw. Was that argument made?
That argument was made in
Was the
my...
argument made to the judge when we're calculating need, Judge, you got to consider the fact that they're saving?
I made that argument on appeal. I believe that the wife submitted proposed findings in which she asked for much more alimony than she got.
But was the basis for that? In other words, was the argument made, Judge, when we're calculating need, they're only talking about consumption, but you have to be considering savings as well. And here's the evidence. Openshaw emphasizes over and over again that if you're going to talk about savings, it has to be shown to be that it was the practice and it was a consistent practice of the parties to save.
That's what the judge found in finding 96, when she says that there were two focuses. One was to provide a home for the family, and the second was to invest in their retirement.
Attorney Lundy, I know that your time is up. I want to just, if you could, in your appendix, you say you've included the plaintiff's trial memo and defendant's trial memo?
Oh, no, I didn't, no.
It's not in here.
No, I didn't, I didn't
It's in
include,
the
yeah.
appendix as a table of contents.
Oh, I'm sorry, that was,
And their
yeah.
post-trial submissions are not here.
The,
Post-trial proposed findings of fact and conclusions of law are not in the appendix.
Your Honor, that's absolutely right. I think the appendix was the.
But how can we consider what you just told Justice Englander if we don't have it?
I'm not asking the court to consider anything that's not in the.
So then we may consider that waived.
Yes, well, you may consider the fact that quoting from the pretrial is waived, yeah.
Because you only gave us post-trial financial statements.
That's correct. That's what the judge ordered. At the end of the day, the judge said neither of your trial financial statements make sense. You both made basic mistakes. I'm ordering you to resubmit your financial statements. So the financial statements that you have.
You want us to only consider what you've given us.
That's correct.
Okay, thank you.
Yeah. Okay, thank you.
Is it Attorney Giordano's going to argue? Okay.
Good morning. Is it morning still?
It is.
Your Honors, Catherine Giordano here with trial attorney Richard Woods, representing appellee Arthur McCarthy. I just wanted to begin by stating that Judge Gargis followed all of the statutory regulations codified at 208, 34, and 53, and she explained herself fully following the order of this court for her to, A, explain how she arrived at the reasonable need of the wife, and also clarifying her rationale for judging the way she did, coming up with her decision the way she did. So there is transparent articulation now, I believe, of the trial judge's assessment of the wife's need for alimony support. She gave rationale which satisfies the requirements of the Bowring v. Reed case.
Finding an average from 15 years back is pretty questionable, isn't it?
Well, I don't believe so, Your Honor, because what the judge did was she took the year 2001, which I believe is the year that Arthur McCarthy started working for the company with the retirement benefits, and she looked at them through 2015. 26 she called an atypical year, drastically higher salary for him that year. I'm sorry, not salary, total income. And 2017 wasn't finished yet at the time of trial.
But, counsel, long-term marriage, I hate to use this expression, traditional roles, 2 children, one person who always out-earned the other. I have not found a reported or unreported case that takes a 15-year average of someone's income to establish a baseline for alimony. I can't find one.
I haven't
and you didn't either.
I haven't either.
Which makes me think it's outside the ordinary course. So then I have to say to myself, what is it about this case? Because the Hassey case, I don't like the Hassey case, but it's the law. The Hassey case says you can do these crazy tiered, hybrid, self-executing agreements. But then the SJC said, yeah, you can do that, but really, if we can do a traditional alimony payment, that's the best way to do it, because these are my words, not theirs. You don't want everybody in each other's proverbial underwear drawer. These folks have to exchange more documents as a divorced couple than they did as a married couple, and it's a recipe for disaster. I haven't looked at the docket. This case, not because of the McCarthys, but the way this is set up, I could see these folks litigating contempts from now till the end of time. This is a case that just strikes out to me as a base alimony amount and maybe a percentage of some bonus if, as, and when. I don't really have a problem with the cap, but the way the judge did this is so outside the ordinary course. Maybe the numbers and Justice Englander's calculations, maybe they end up falling in the correct spread in the Alimony Reform Act statute, but this just is such an unusual way to handle alimony. There was a reason to do it in Hassey. What's the reason to do it here? We don't have crazy components. We've got base, we've got an EBITDA bonus, and we've got a discretionary bonus. Those are easy things.
Right, but there is case precedent on using an average of income.
Give me some cases.
We made, well.
Other than Hassey.
I believe they've been mentioned in the brief, Your Honor, but the idea was, I didn't know that she had to have a 15-year case on the record before she could use that. I thought it was an exercise.
15, but give me something. I've not found a case that says that a 3-year average is kosher or a 10-year. These cases just don't exist because I think judges don't do this.
Well, I believe I've cited to one with a 9-year average, Your Honor.
All right, I'm going to look right now.
But I believe the judge was just trying to get an average long-term income to focus on, but the result of the entire picture.
His income did not roller coaster the way some if a person was self-employed, we see that. This guy didn't roll, he had some exceptional year. I agree with you, and the judge handled that, and it probably makes sense. But I don't see this as this extraordinary case that requires us to do something so unusual.
Well, in terms of being unusual, I suggest that the Young case leaves the door wide open for special circumstances, some of which might be what happened between 2015 and 2016 being extraordinary.
So their marriage broke down and they weren't having sex. That is not unusual. As a former divorce practitioner, that is not unusual.
I would agree.
Let's just look at the numbers for a moment, because I have to say, I thought that they were some pretty broad. I mean, when you do a pension, for example, you look back 3 years or 5 years, right? And so maybe that's a presumptively a better way to do this. But, in 2011, so 5 years before the spike, 191,000. In 2009, 158. There's a swing of over $100,000 over the course of the last 7 years between 2009 and 2016. Twice, because it goes to 291, then it goes to 400. That's the outlier, right?
Yes.
So the judge has this situation where the bonus is important, right?
Yes, Your Honor.
And so you know, it seems odd to go back to 2001. And the reason it seems odd to me to do this, and I am not nearly as experienced as you folks or as the judge to my right, but it seems odd to me because people's income tend to go up. As they work longer at an institution, their income goes up, and it can go up really substantially. And if you go back that far, it's not fair because the lifestyle has changed significantly as the income went up. And I think that's the problem with going back 15 years. You go all the way back to $120,000, which is nowhere near what he was making in 2016, 2015.
Well, I think.
What do you say to that?
Well, I think that the task the judge had in front of her was to determine need for the alimony, and for that she was looking at lifestyle. There was no question that the husband, she believed, could handle maintaining the same lifestyle throughout the whole marriage, which...
Is there any suggestion that they were living the same lifestyle in 2016 that they were living in 2001?
Well, there's a finding of fact by the judge that in fact the spending towards the latter part of the marriage did not reflect that
But see, those
their
words
lifestyle
are the
changed.
words toward the latter part of the marriage. That suggests he should be looking towards the latter part of the marriage rather than 15 years.
No, the only explanations I can offer are that Arthur started working for this particular company with the benefits in 2001, and she's looking for a long-term income averaging. That's been done in cases before, and this is a total picture she's coming up with. This is not a case of one size fits all. She's trying to piece together her different elements that she thinks are appropriate and equitable to the total alimony. And I think in this case, she was looking to see a longer period of income averaging because that's the whole time that he worked for this company. And she wants to get something that isn't going to have an outlier year in it, to have something accurate for her to work with.
I think you could consider the outlier of that 1 year without going back 15 years. And I just looked at your brief, right? So you cite Civides, which is the case everyone cites, except the facts there are so radically different.
Yes.
They had separated, they had lived separate and apart for 15 years, their finances were separate, everything was separate. The only thing that hadn't happened in Civides is they got a divorce. So Civides is such a different fact pattern. But then you cite LaValle and Whalen, and they say in those cases, and that's out of this court, that the averaging method is appropriate where the income might fluctuate widely. We have 1 year of fluctuation. Otherwise, we have this slowly, steady up, which makes sense. The longer you're with your company, presuming you're doing well, you're going to get raises. He became a key man for the company and had certain benefits inure to him because he was a key man. That's consistent with the increase in income. It seems to me that she, the trial judge, depressed his income artificially by going back 15 years. Maybe you handle those outlier years differently, but I'm struggling with how the 15 years is truly representative of the here and now of his ability to pay and her need. And she did list, I went back and looked at the impounded financial statement, retirement as an anticipated expense. So that was before the court, even though Openshaw was decided, I think, after the first remand, but before the second judgment.
That's correct, Your Honor. And Openshaw can be distinguished from this case certainly because the wife in Openshaw listed on her weekly expenses in the financial statement savings, and of course...
She did here too. It's in the impounded financial. I just looked at it.
Oh, because I didn't see that under weekly expenses.
Oh, yeah, it's on the addendum.
And her savings account, certainly, you could tell by her property division, which was much lower than his, but savings were taken into account in her...
Record 4, page 23, just so if you want to make a note of that for the future.
But the issue I wanted to get back to was her distribution also reflects, don't forget, the income here is not just his base income, but his bonus income. So I think that the whole purpose that she did that long-range average was because the Social Security earnings statement was in evidence, and you can't just look at his base income. You have to look at the base income and the bonuses. And that was certainly very variable over the 15-year stretch. And I think that provides ample cause and justification and quite reasonable and consistent with their findings of fact to look at a longer period of time. Because looking at that Social Security statement, you see that the income does bounce around quite a bit, because that was certainly a variable.
Also, the Social Security statement is not in the record appendix, and it's not in your supplemental appendix. So we're tied to what we all have in the record.
I also wanted to mention, the point was brought up about the several years not being defined, but in the trial record, you'll find that Judge Gargas did define the word several as being 3 years. But that...
In what context? I'm sorry.
I'm sorry, it was brought up earlier that the word several wasn't defined as far as her terminating the marriage early.
Oh.
Yeah, I'm sorry, I'm skipping.
I wasn't sure where you were.
Okay. But in terms of the need of the wife, the judge was left with whatever she presented at trial as her need for alimony, plus her proof of lifestyle, which we addressed in the brief already. In terms of need, she now tells us very clearly that that she came up with $22.83 for weekly expenses. And how did she get that? It's readily apparent, as the standard requires on review, that the judge subtracted out certain figures from the wife's most recent financial statement with weekly expenses that she did not find credible under findings of fact, paragraphs 42, 84, and 86. If you look at RA4, pages 20 and 23, the amounts next to the category house supplies, incidentals, toiletries, furnishing the house, new hot water heater, new furnace, vacation, and air conditioning were all what she deducted for a total amount of $1179. So we have her calculations to the penny as to how she came up with the actual, what she called the reasonable need of the wife. If you put together everything that was given in terms of the additional bonus, which it's clear she needed to do something in a percentage basis because the husband had not achieved it, and she was trying to avoid the problem that was explained in Young of the law prohibiting paying the wife more than what the husband might possibly earn.
Right. No windfall.
Right. There's no windfall to the payee spouse necessarily. And in the Young case, it was an asymmetrical division for good reason.
I don't understand, and this is because of my lack of experience in this area, what the alternative would be to what she did. It would just be setting an alimony figure based on an average of both the bonus and the base?
She could have come up with a firm figure in her alimony award of what he owed the wife, but the danger of that would be running afoul of the rule that says you may not give the wife more money in alimony than she was accustomed to during the course of the marriage historically.
Or she could have set a base on something less than a 15-year average and did a percentage of the bonus, similar to how she handled the SARS and the ESOP with some kind of a declining staircase with a cap.
But if
Yes.
she does that, then you still have the problem that the chief was mentioning, that they're going to be exchanging documents every year with respect to the bonus.
I really think that Judge Gargas goes to a great extent to avoid future litigation because she takes note that with her style of handling this alimony, she has clearly, first of all, explained herself as the case law and the statutes require for what she did. But secondly, I think that she explained very carefully that the reason for her jumping outside the norm here. And the reason was because she was afraid that perhaps Arthur would not earn enough money to pay what she ordered for alimony, and that would cause a modification order. I think by doing it the way she did, she permitted the wife to have sufficient funds, and not only that, but to have more than sufficient funds to have enough money left over for voluntary expenses that were not listed on her weekly expenses.
I think we are going to have to leave it there. Thank you.
Okay.
The case is under advisement. Our last case is the Department of Children and Families and Others versus Mother and Another, docket 24P 765. I know we have experienced counsel. As you approach, I just remind you that the case is impounded, so you are not to use any names. And if there are parties in the courtroom, they cannot sit at counsel table, and they must comport themselves appropriately. Thank you. And just while we're getting set up, Attorney Gallup, you're going to take 8 minutes, and Attorney Goldberg, you're going to take 7 minutes. Okay, that's great. And Attorney O'Tay, you're going to take 15 minutes. When you are ready.
Members of the panel, may it please the court. My name is Molly Odie, and I represent the appellant mother in this case. Mother is asking that this panel vacate the decrees of the lower court terminating her parental rights to her 3 children and remand for further proceedings. Today, I'd like to focus on the second issue that I raised in my brief, which is the issue of the failures of DCF's reasonable efforts. This is a rare case where the reasonable efforts issue is actually well preserved, and we specifically contend that the juvenile court erred in finding that DCF remedied its failures of reasonable efforts by the time of trial. In fact, the trial court found the DCF had failed to make reasonable efforts just weeks before trial began, and it's clear.
On a motion that was filed just weeks before trial began.
The motion was filed, I believe, at the end of October, the beginning of November.
Trial was December 2nd or something like that?
Trial was.
The time that a motion on reasonable efforts was filed was October of the same year.
That's right.
Was reasonable efforts ever raised prior to that?
So one of the issues that was raised in the reasonable efforts motion was the issue of family therapy, which I think is one of DCF's most egregious failures in this case. And there's a language from the DCF supervisor in the 2022 court investigation report that basically says mother had been asking for family therapy for years. And the court found as well that mother had been asking for family therapy for years. So while it wasn't necessarily raised in a motion, DCF had been on notice for years that this was something that mother needed, wanted in order to.
Other than family therapy, what else had been raised? How had the problem of visitation been raised with DCF prior to October of 2023?
Sure. Mother's affidavit for the motion says that she had spoken with DCF about this for years.
Spoken with DCF about it in what way?
I'm not sure the exact nature of those conversations. However, you know.
When did, just help me, I'm sorry, sure. I should be more facile with the facts, but the children were moved to New York in what year?
They were moved to New York in the summer of 2021.
2021, yep. In the middle of COVID?
Yes.
And at that time, they went to 1 month, 1 meeting a month.
Yep.
The children were brought up to Boston. And there was no, what's the mechanism for complaining about that is a
abuse of discretion.
Abuse of discretion motion. No such motions were filed. Nothing like that.
No motion was filed at that point. No.
Okay.
However, it was clear that in several of the court investigation reports, there's one of the children's therapists talks about the child not being excited about the travel. We have other language that comes up. I believe the adoption worker says that the New York social worker acknowledged that the children didn't want to make this, that the travel was long and tiring.
How old were the children when they were moved to New York? They were been left 12?
So that was 2 years before trial. Yeah, something like maybe 14, 12, and 5 or something like
14,
that.
12, 5?
Or 4.
Okay.
Yeah, something like that. So, on that note, the move to New York was, the mother wasn't told that they were being moved to New York, right? This is one of DCF's egregious actions in this case. They basically kept this a secret from Mother. She expected to go to a visit the next week. Surprise, they've moved them out of state. And that was very upsetting.
Before that?
I believe that initially in the case they were visiting weekly, and then it was reduced to.
The case started in 2020.
The case started in 2018.
2018. So the removal is 2018?
Yes.
Okay.
So, it was moved to twice a month, and then after the kids are suddenly moved out of New York, suddenly moved to New York, then Mother's visits are lessened. She only gets one visit a month with them for 2 hours. They are tired. When they show up at these visits, it's in a room. It's not until DCF decides a few months before the case to start supervising the visits. DCF hadn't been providing support.
At the time the children are moved, what's the goal that has been set? Is it adoption?
At the time of removal, it was reunification. Adoption, I think the permanency plan changed to adoption a year later in 2019.
Wait, no, I'm sorry, I may have misspoken. At the time the children were moved to New York.
Oh, at the time that the children were moved to New York, it was still adoption. It was adoption. Yeah.
It was adoption. So adoption was set in 2019.
Yes.
Okay.
And they are placed together in New York, 3 siblings with the same pre-adoptive home.
Yes. Yeah.
And what I inferred from the materials was that was a gating factor in placing the children closer. Was someone who would take all 3.
I missed the first part of your.
That was a gating factor, was finding someone who would take all 3 children.
Yeah, I believe so.
Because the range of ages is very significant, and one of them is an infant.
That's right. So we have these kind of series of issues with DCF, the sudden removal, we have the reduction in visits, we have the trouble with visits, and then we have the social worker on the stand said, when asked about family therapy, Mother had been asking about this, the court ordered that it be implemented, or that it be a referral be made in November, and the social worker said, nothing had been 18 months prior to trial when he started on this case. They hadn't initiated family therapy. The foster care review in September of 2023, several months before trial, suggested DCF hasn't been providing Mother with information for the children's providers, and family therapy should be attempted. So other people are recognizing, that there's an issue with what the provision, the access that Mother is being given to be able to understand the things that DCF is expecting her to understand about her children. And they're recognizing that there needs to be work done on the relationship, and, we have evidence that Mother had been asking for that work to be done. DCF didn't do it until the court forced them to, and even then, by the time we get to trial, it hadn't been implemented. It was, a referral was made, and they heard the girls don't want to do it, but they didn't make it happen. And so.
Well, but by that point, you've got 2 children over the age of 14.
Sure, they're over the age of 14, but we don't let that be we don't let, even though we consider, in our case, we consider what children over the age of 14 want, they don't get to determine whether or not their family is over, right? Guardianship of Raya, we give them some weight, but they don't get to make that determination. And there are so many other things that DCF could have done.
I'm confused about that, and it's probably because I don't know the law well enough. I thought at the age of 14 you could, for example, reject adoption.
I think that you can. Do you
think by the age of 14 you can reject a request to meet with your biological mother?
I certainly think, I'm not suggesting that you're going to force a 14-year-old kicking and screaming to go into a visit, but they don't get to say, my mother's rights should be terminated,
Don't they have to consent to the adoption, the older 2 at this point?
I believe that they would have to consent to the adoption. That's my understanding, but I don't think that they get to say, they don't get to say my parents' rights should be terminated.
No, of course not. That's not the point.
Yeah.
I mean, we actually had this problem, a similar problem. It was with an 8-year-old, and one of these children is of that age. and sort of what is DCF supposed to do if the child reportedly will not meet with the biological parent. But I thought that that problem dissipated at age 14. And you're telling me you don't think so.
I think that it shouldn't be dispositive, and I think what I'm arguing is that DCF, they're using this as a way to just throw up their hands and ignore the fact that they contributed to this problem. So DCF can't say, you know, we knew that this family was having issues and we didn't implement anything to try to help them, and now, you know, they say that they don't want to do it, we're just going to stop trying. I think that they have to be more creative.
What
Right?
do you think they were ordered to do by the reasonable efforts order in November of 2023?
What were they ordered to do?
Yeah.
There were
What
several.
was the finding as to what reasonable efforts were not done? I read it and I was having trouble. I was struggling.
I think that it was there were no written findings, so it was whatever was, the judge said at the hearing. But my understanding was that the judge ordered an updated action plan, visitations to take place. It was unclear whether or not they were supposed to be in New York.
Exactly. I mean,
And then-
the judge was asked, are you ordering us to bring the children to Boston? And the judge said, my order stands. I mean,
Right. The mother did ask for them to be in New York, and so, yeah, you could read it that way, but then, the
I'm
court
sorry,
also.
it was the other way around. Right, yeah.
The court also, ordered this referral, an emergency referral for family therapy.
The court ordered an emergency referral for family
Yes.
therapy. So that's one thing that had to be done.
Yeah,
And face-to-face meetings, to which DCF responded, we already do that.
it had been 6 months, between June of 2023 and December of 2023.
And one.
It's been 6 months of no visits.
Because DCF reports that the children are not willing to meet with the mother. Or that some of the children are not willing to meet.
That's what
Not all of
they
them,
said.
some of them, right?
Yeah, that's what they said, and I think that,
Is there a way to challenge that? Is there a way to, I guess it's an abuse of discretion motion and taking findings?
well, I think that that's what happened, right? I think there was a September pre-trial conference that Mother's Council raised the issue of visitation. Then she objected to the permanency plan in October, and then there was the reasonable efforts motion. So she was making, at that point now, that's like 3 months after visits aren't taking place. She's raising this issue. By the time it gets to December, then that 6 months have gone by at that point, But
even if the judge were to find that there was an abuse of discretion, my understanding is all the judge can do is order DCF to follow its regulations, right?
So I think the issue is that DCF, kept claiming that the children were not interested, but they weren't doing anything to make it easier for the children to participate in these visits. They didn't say, oh, this is a problem that the children are saying that they don't want to visit. How can we fix this? How can we make the visits happen in New York so that they're easier for the kids to access? Or can we, do them in a different location? Can we implement family therapy so that there's, some, restoration of the relationship so that they're interested in attending the visits? I think that the issue is not whether or not DCF was technically complying with the letter of the law here, but whether or not they were actually attempting to do their statutory duty of seeking reunification here and helping heal the family relationship. So I think that is a significant concern here, and I think by the time of trial, not much has really changed. Sure, family therapy referral was made, but it wasn't actually, the evidence is that it wasn't actually being implemented by trial. We've already discussed this. One visit took place, which seemed to go well, which suggests that with more effort from DCF, the challenges to visitation could have continually improved. It also casts doubt, I think, on the...
The visit in December was with two of the children?
The visit in December was with the middle child and the youngest child. And at that visit, the youngest child initially said he wasn't going to go, and then he went, and the DCF worker said he sat on mom's lap. He showed affection to her. He appeared to enjoy himself. So that casts doubt on, what's going on with the children rejecting the visits. The middle child also didn't ask to end the visit early. Mother talked to her about her life, about school. She gave mom a hug. So that also casts doubt on, the supposed unwillingness of her to engage in family therapy that DCF alleged at trial. The court.
How does that even match up with the evidence that's emphasized in DCF's brief that child, the middle child, was asked whether if mom came to New York, she would meet with mom, and she said no. The two don't even match up, right?
I think that the issue is, how often is DCF asking and under what conditions? I don't know, but we see evidence.
When did she supposedly say no? Before or after December?
I don't know if that information is clear from the record.
Not very helpful under those circumstances.
But I think we see. Seeing that my time is up, Mother will ask that this court vacate the decrees terminating her rights.
Well, what remedy, if the panel were to agree that there was a reasonable efforts failure, what remedy would you say is appropriate?
I would say that the Alona suggests that the court should consider that mother's unfitness was only temporary and that it would be in the best interest of the children not to terminate her rights. Mother doesn't concede her unfitness, but if this court were to find that, then at least there would be no termination, would be the remedy.
Thank you.
Thank you.
Attorney Gallup?
Good afternoon. May it please the court, Julie Gallup on behalf of the Department of Children and Families. The department is asking for this court to affirm the judgment. I would like to address the reasonable efforts and the family therapy, as much has been made about that, and that was addressed previously. There was testimony from the social worker that the purpose of the department wanted mother to engage in individual therapy to help her to understand why the children would have a difficult relationship with her, to help her to understand why the children would have PTSD from their experience living with their parents. That was the purpose of individual therapy, and mother stopped that, I believe, in December of 2022, a year before the trial began. So family therapy, there was testimony that family therapy wouldn't work if mother didn't have an understanding about her role in the difficult relationship with her children. So that was the reason why the department did previously make
Where did that testimony come from?
So I have
that come from the social worker?
Sorry. The social worker testified that at transcript 202 to 203. And where the department wanted to help have mom.
Sort of a condition precedent to family therapy would have been sort of a successful individual therapy? That's what the testimony
Yeah, the
is?
point of the individual therapy was to help her gain the insight into the impact of the neglect that the children experienced living with their parents. And so, and the department had previously to that, after the order and the reasonable efforts hearing, prior to the case, prior to that hearing, had made referrals for family therapy. But at a point where mom didn't really have an understanding about her role in the fractured relationship with her children, it didn't really seem like it would not have made any difference. Additionally, mother didn't have an understanding about the children's various needs. There in the record appendix, it appears that the older two, the girls had diagnoses of PTSD as early as 2022. it is in the court investigations and in the court reports. Mother, at the trial, was unable to identify that the girls had been actually diagnosed with PTSD. And when asked why they could have been diagnosed with PTSD, she only identified her relapse and their father's passing, which occurred at the time of their removal in 2018. It completely ignored anything that could have occurred while the children were living with their mother before their removal. And there was a long history of substance-related issues. In fact, there was 151A filed that mother had passed out and overdosed while caring for the girls when they were much younger. So, mother's unfitness was more than temporary, and the department made efforts to help her gain the insight that she needed. In fact, the department even offered at a home visit in December of 2023 to make a referral for an individual therapist so mother could, start that process. And mom said, I'll just work with, the agency that's providing me with my medication.
So I see reasonable efforts as sort of a two-way street, right? That the department has an obligation, but that the parent also has an obligation. And I think I read your brief to say that mom didn't meet her obligations either. So tell me what it is that mom, in your view, did not do.
Well, she avoided, or, she was unavailable to meet with the social worker for several months. I believe in 2022, maybe only met like 2 or 3 times, or 2023, I don't have the months in front of me, but she was supposed to meet with the department on a monthly basis so the department could check in with her, figure out what services she's engaging in, and to have conversations with her to determine whether or not she was gaining, the insight and to change her parenting.
Did she sign releases?
She did sign releases, and that's also another issue, because she had signed releases for her substance abuse provider, but the department was unable to obtain screens from the provider, and in fact, at one point, mother became aware that the department was calling her old clinician, and she didn't take any steps to actually say, hey, department, you're not reaching the right person, and that's why you're not getting any information from me. So mother also, with regard to the youngest child's school, in 2022, the department provided mother with that child's school's contact number, and I think it was like in March or May, they called the school, and mom had a conversation so she could understand what services, what's his IEP like, and the plan was to meet with the social worker the next month at a home visit to follow up and continue checking in, and mom canceled or just didn't show up. And there was testimony from the social worker that there would be months where there would be an appointment made, mom would cancel the day of or the day before. Social worker even had to go, would go by mom's house unannounced just to try to meet with her because there were gaps in contact.
What cases do we have factually that's similar to this on reasonable efforts? I mean, I know post-Rashida we don't have much published, but anything like this? I mean, especially because the whole concept of the Rashida motion is so new. So the fact of, an order with with remedial or, that includes, take these steps. I don't know that there's a case that says if there's a finding of no reasonable efforts and you need to do certain things, and then a month later, the judge decides that that's sufficient time to rectify previous deficient provision of services. I don't know that there's a case that speaks to that, but the judge did find, though, the department rectified, what it had found was, when it was not making reasonable efforts, it made the referral for emergency therapy. It was already providing in-person visits, and it updated mother's action plan. Those were the 3 things.
They weren't providing in-person visits in New York, though, right?
The department did not provide in-person visits in New York.
Is it true that the children were moved without even notifying mother? I didn't see you contest that in your briefs.
So, in April of 2021, there was a adjudication of, mom adjudicated to unfitness. And so basically, all information that's kind of earlier in the case is not available to us. Although I do know that the children were moved in July of 2021. I think that it appears in the record that mom wasn't notified in advance that this was going to be happening. But I think that the department was...
But mom knew there was a kinship placement that had kind of exploded and you were looking for other placements, right?
Correct, yeah. And the department had found a family in Massachusetts that was interested in taking all 3 children. That fell through. That was in 2020. So, the possibility of finding a family that wants to take teenagers and a younger child, it's hard to find. So a family in New York was identified. And at that point, the goal had been adoption since 2019. The department also needed to make reasonable efforts on behalf of the children.
We will have to leave it there. Thank you.
Thank
Attorney
you.
Goldberg?
Thank you. May it please the court. My name is Lane Goldberg, and I represent the 3 children who wish to remain where they are and have their adoption finalized. They do not wish to be reunified with mother. Mother is unfit, and 5 years after the children's removal, mother continued to abuse substances, misused prescription medication, and she didn't have meaningful contact with the children. She lacked insight into their special needs, and she had not secured steady housing. This unfitness, coupled with the fact that the 3 children were vocal about not wanting to reunify with an unfit mother, demonstrates that the trial court made no error. I want to address, Chief Justice Blake, your comment of reasonable efforts as a two-way street. That's correct, and there is a case, adoption of Paula. I haven't seen any cases where there was a reasonable efforts motion that was decided by the trial court a month before trial, and then the judge has said that they've corrected that. But adoption of Paula does state that the mother's failure cannot be laid at the department's door. This was a DV substance abuse case, and there's a line of cases here that suggests that it is a two-way street. The department does have a duty to, help assist mother make reasonable efforts towards reunification, but at the same time, mother's efforts were severely lacking here. Another case, adoption of Daisy, a 2010 case, the quote here from the court, the obligation to work with the mother was contingent upon her own obligation to fulfill various parental responsibilities, including seeking and utilizing appropriate services. My sister just spoke about the lack of therapy, and also with regard to the visitations. There wasn't really an effort on mother's part to have meaningful contact with these children. She was often late to the visits, and it began from the record shows from the beginning she was offered the chance to have communication with the children's first placement, and that was stopped because of inappropriate conversations that were made. And then there were
Mom ever seek a continuance of the best interest trial following the reasonable efforts order of Judge Griffin?
No. To my knowledge, no. There was no motion for continuance. So you're talking about when the motion was the reasonable efforts? No, there was no motion to continue that was filed on her behalf.
The circumstances of the visitations they're pretty extreme, don't you think? I mean, you're saying you can meet with your children for 2 hours once a month, and they're going to have driven 5.5 hours, and they're going to have to drive another 5.5 hours afterwards.
Yes, and I think that you had brought up in the record that the oldest child and the middle child began to refuse the visits with mother even before they were moved to New York. So that's at record 210. In the children's home, it wasn't in the Commonwealth. It
That's
was
2021 or 2020. You say, we'll find in the record that the two older children were beginning to refuse visits when
Yes.
they lived in the area.
in the area.
And they were what ages at that time?
At that time, they would have been about 11
13
or-
and 12, 13 and 11? Okay.
Also, the record establishes that the children stated that they would not attend the visits even if they were in the state that they lived. So if mother were to travel to New York,
When was that statement made?
that was at the trial transcript, pages 230 to 231.
When did the child say that? The middle child met with the mother in December. The report is that it went fine. So emphasizing that fact bothers me because I don't know when it happened, and it seems inconsistent with the fact that the middle child did meet with the mother.
Well, the middle child did. The oldest child didn't meet with her, and there was,
Okay,
in the
but
record,
the one I saw quoted in the briefs was from the middle child.
that the
That
visit
she,
went
even
well
if the
and-
mother came to New York, she wouldn't meet with the mother. Well, she did.
I know that the oldest child would sometimes drive the entire, or sit in the car the entire way and then not even go into the visitation.
Okay, but that's...
But the middle child, I'm not recalling when she had said
I
that.
thought that the middle child was vacillating, and at times she would say she wasn't going to go, and then she'd get there, and then she would visit with mom.
Yes.
Is that correct?
Yes. She would go, the oldest child would not go. There was an incident where mom asked how old she
Right,
was,
I think
and that
mom was
just,
consistent, eldest child was consistent. I think it's the middle child that, from my memory of the
You are
transcript,
correct.
seemed to vacillate.
you're correct. And then the youngest child would sometimes go, sometimes not.
And it
At
seemed
the-
like he was dependent on what the middle child did.
Yes.
If she went, he went.
Yes, and then sometimes the visits were stopped early because the middle child would leave early.
Right.
And mother would not encourage the youngest child to stay. Your assertion that the December visit went well, there are notes in there that at that visit, the youngest child ran off and mom couldn't keep up with him. At that visit, mom was late. And so, at that visit also, the mom tried to share her phone number inappropriately with the middle child when she wasn't supposed to. So the visits, in general, over the year prior to trial, were not going well.
So is it, and I don't know the rules, but is the rule that the child can't choose to talk to the mother once they're in foster care?
At
At
I
age
believe
14?
I believe the department has control over that, and the department can, based on mother's prior actions, determine whether or not the contact was,
Department has custody.
yes.
And they're worried about something potentially being, not necessarily in this case, in any case, about what the appropriate level of
Yeah, and there
conversation
was,
is.
in the record, it demonstrated that mother was talking about the mistrial with the younger kids, and then they would have, they would have setbacks in therapy. I see that I'm over my time.
Let me see if there's any other questions. I don't see any, so we'll have to take the rest of your argument on your brief. These are very difficult cases. We appreciate argument of all counsel. We will give it our due attention, and it is under advisement. That does conclude today's session of the Appeals Court. I'd like to thank our staff, in particular our court officers, our clerk's office, our law clerks, and our fantastic timekeeper. We are now in recess. Thank you.
Thank you.